Good morning, good morning, good morning, everyone. How are you? It's good to see you. Good morning, Harley. Good morning, preschool granny. It's good to see you guys. Excuse me. So today we are going to resume with day 5. And hold on a second. Alice is tearing up the carpet. Anywho, we're going to resume with day 5. We're going to do it backwards because where we left off Monday is with Mr. Jake, Todd Mullis's original trial attorney. And the way scheduling worked, he actually testifies at the end of the day on day 5. But you know me, I like continuity. So we're going to start with him. He is appearing by Zoom. Unfortunately, for whatever reason, the closed captions are not available. I don't know how the audio is because I haven't had a chance to check it out. Probably should have done that before I went live, but I was working on the documentary for Kai that I'm going to premiere only on Patreon because of the subject matter. So there's that. What else? I think that's it. Wait. I forgot one thing. I told you guys on Monday that Paul had emailed me and he had some really, really great notes. And so what I want to do is make a separate video for with that and with using Paul's notes, because it's important stuff, and it's kind of hard to like completely recap it before the testimony for the day, since the testimony is so long. I think that it would be better in a video format, so be on the lookout for that. It shouldn't take me too long to do that, but so that's what's going on. Also, if you haven't done so, do me a favor, give your girl a thumbs up on the stream. I appreciate you being here. Let's get right into it because we have a lot of testimony today, and like I said, we're going to start with the original trial attorney. And as you know, that's probably going to require a lot of commentary, so probably a lot of pausing and stuff like that. So I want to make sure that we have plenty of time to get through it today. All right. So without further ado, day 5. Oh, I thought I had it right at the part, but apparently, there we go.
All right, good afternoon. We'll go back on the record. Mr. Firehelm, are you able to hear me? And you are muted currently.
Yes, I can hear you, Your Honor.
Okay, you are very quiet. Is it possible for you to turn up your volume?
I have it as high as I can get it.
All right, I'll see if we can turn up ours, maybe. All right, would you try it again for me, please?
Yes, Your Honor.
All right, that's much better. Perfect. Okay, counsel, I think we're picking back up with Mr. Firehelm's testimony. Is that correct?
Yes.
All right, Mr. Firehelm, I will just swear you in again quickly since it's a new day. If you'd raise your hand. Do you swear the testimony you're about to give will be true and correct?
Yes, Your Honor.
All right, and I know that the camera angle is not the greatest, but hopefully you can see counsel well enough. Counsel, if you need to move or adjust yourself in the courtroom, please feel free to do so.
Thank you, Your Honor. Thanks for coming back today, Mr. Firehelm. We appreciate it. I wanted to pick back up discussing the discovery that you were tendered before Mr. Mullis's trial. Do you recall if that discovery included audio and video files?
I believe it did. I'm not 100% sure.
Mr. Firehelm, for some reason we lost your video. I'm not sure. There you're back. Okay.
Do you recall specifically audio and video of an interview with your client, Todd Mullis, November 16th, 2018?
If that was the interview by DCI, I believe he was at the law enforcement center. Yes, I do.
Do you recall reviewing one of Tristan Mullis done by DCI, November 16th, 2018?
I think so, yes.
And are you familiar with investigative techniques such as the Reed technique?
Yes, I am.
And is it your understanding that the Reed technique is designed to obtain a confession from a suspect?
I believe so, yes. That's my reading of it.
Did you consider or investigate whether the DCI agents were utilizing such techniques on Todd Mullis and Tristan Mullis?
I didn't match up their technique with the Reed technique, although I've seen DCI use it pretty consistently.
And Your Honor, I'm going to object on this point solely for the fact that evidence already within the record has testimony that's been uncontroverted essentially at this point. As Special Agent Turbot testified, he did not use the Reed technique, if I remember correctly.
Overruled.
Mr. Firehelm, I think my question really is that you had some education or knowledge about interrogation techniques at the time you represented Mr. Mullis?
That's correct.
And did you take any actions or conduct any investigation to have those interviews reviewed by somebody more knowledgeable than you?
No.
Could you have consulted an expert regarding coercive interviewing techniques?
Yes, yeah, they're expert for everything.
Did you consider investigating or locating any witnesses that could testify to Todd's good character?
I didn't. Bob had a lot more contact with local people and family than I did.
Great, thank you. I know yesterday we talked a little bit about the 911 call that the state played during trial. Do you remember that discussion?
Yes.
Do you recall if you listened to it before trial?
Yes, I'm certain I did.
And then do you recall ever playing it for Mr. Mullis?
I do not recall doing that, no.
During Mr. Mullis's cross-examination, did you consider objecting to the mischaracterization by the prosecutor that Todd was alone at the time of those purported statements?
No, I don't think so.
Did you investigate the timing of the purported statements in order to contradict that state's argument?
Are you referring to the cross-examination questions or that claim by the prosecutor that he was whispering something to her? Is that what you're referring to?
Yes.
That wasn't an issue. There was no warning about that at all until it happened.
And so you weren't able to look into the timing of those statements?
No.
If you had had notice of those statements, could you have done some investigation to learn whether another deputy or another person was on scene at that time?
Well,
Okay. So I just have to do some really quick commentary here because this is always, I didn't understand this. I don't, or if I did, I don't remember it from the original trial. I did not realize that when Todd was on cross-examination and they played those portions of the 911 call where he was asked if he called her, I believe the words were cheating whore. And there was another phrase, but now it just escapes me. But anyway, I didn't realize that the defense was not ready for that, that they had no idea about that, which is a violation of the rules in criminal procedure. The state was required to turn that over to the defense when they learned about it. And the fact that he didn't immediately request a mistrial and stop the proceedings right then and there, I will never understand because, as I pointed out when we heard this on Monday, when Sarah Boone was, during Sarah Boone's trial, during closing arguments, they played the suitcase video, and George's family was sitting in the gallery, and I believe it was his mom who gasped, and then she was crying. And Owens lost his whole mind, acted like that was some kind of something that was planned by the state and he wanted a mistrial, blah, blah, blah. Okay, that's not really a great reason for a mistrial, Mr. Owens, but you took the shot. This guy didn't even take the shot. Also, let me say good morning to you guys that have just come in. Good morning, Chicken Lady. I'm sorry you're not feeling well. I hope you feel better. Good morning, Mrs. Troy. Good morning, Violet. Good morning, Patricia. It's good to see you guys. Let's keep going. I just wanted to pause there to remind you guys in case you forgot, because we did get a little sidetracked with Lori yesterday. And quite frankly, I'm sorry that I couldn't do both yesterday. But at the end of the day, I cannot miss an opportunity to take a swipe at Lori. I mean, look, y'all, she showed up to court representing herself. Yeah, she's got, standby counsel and whatnot, but regardless, these are her choices. She showed up looking like some combination of Charo if she was a demon, a Shih Tzu, and the Cowardly Lion after he visited the salon in Emerald City. Like, bruh, come on. Too much. I had to cover that. All right, here we go.
I think it was pretty clear there was another deputy on scene. There was back and forth between Todd and a deputy before that allegedly happened.
Okay, and you didn't point that out during trial?
Again, it came up right there at the end in almost the last question she asked him or presented it to him. So no, I didn't.
Thank you. I want to move on now. Do you remember the name of a witness, Tom Krogman?
Yes, I think so, yeah.
Do you recall there being a DCI interview that included audio?
I don't. I'm not saying there wasn't, I just don't recall it right now.
recall in your review of the discovery, DCI agents telling witnesses that the medical examiner's opinion was gospel?
I don't remember that being said.
Did you consider calling Mr. Krugman as a witness at trial regarding his observations during the emergency medical services on the side of the road or his observations at the hospital?
I don't think so, no.
Do you recall an email between you and Mr. Sabers about whether you should call Mr. Krugman?
Not specifically, no.
I didn't make it. Hey, Josh. Zoom.
Just a moment, Your Honor. I think I'd like to refresh the witness's recollection, but between the Zoom and the sharing, I need just a moment here.
Okay, just let us know when you're ready, please.
Oh, thank you, Preschool Granny. I think you are awesome as well. And thank you for understanding. Violet says it's okay. Lori is a full-time job plus a side gig. She's a lot. Yes, she is.
Your Honor, at this time, we'd like to share our screen.
And Patricia Burns says, her behavior, Lori's I mean, and what she had to say during the interview were quite frankly obscene and narcissistic in a very predatory way. I was sickened by it. I have to agree with that. Hey, Queen of Hearts, good to see you. Good morning, Shelley Bean. Yeah, that Dateline interview was beyond ridiculous. She clearly had a motive, right? But then how are you going to say, I don't want cameras in the courtroom, but I'm going to haul my cookies up to, I'm going to haul my cookies on Dateline. Give me a break, Lori. And all of that really is about Lori wanting control over what is seen, what is said, who sees it, who says it, all the things. She just wants to be the boss of everything. No, Lori, no, it doesn't work like that. And also her statement yesterday at the about people trying to get on the jury because they know it's her. Well, that's not completely untrue. I mean, that does happen. It has happened before in other trials. That's what the voir dire is for, is to weed them out, to make every attempt humanly possible to get jurors seated that can be fair and impartial and only base their verdict on what they hear and see in the courtroom, nothing else. We're dealing with people, okay, when we're dealing with the jury system, and people will people. Is it possible that one slips through the cracks? Obviously. And it would be wrong for somebody to do that, but it does happen. And at the end, and I cannot forget to point out, right, that people can be deceiving. Ain't that right, Lori? I bet your kids didn't see you coming the day that you murdered them. That's all. Here we go.
To show an email to Mr. Firehome, but we're not seeking to admit it. It's just to refresh his recollection.
Fantastic. Hold on. I have got to say, hey, Nate dee, bendy Lou, my boo-boo, can't chat, but listening while I get ready for work. Okay, you guys, I don't know if Nay has had an opportunity to put it on the website yet, but last summer, she and I talked about a new scent in wax melts, okay? And it is inspired by the Violent Femmes, Blister in the Sun. That's the name of the scent. I don't know if she's had it, had an opportunity to put it for official on the site, but it will be. I cannot wait for you guys to see it, and I cannot wait to order it. It was inspired by your girl, Bindaloo. I'm very excited. Okay, babe. She says, not yet, but I will try to remember this afternoon. I'll message you to remind you just whenever you get a chance because I'm so excited to order it. All right, you guys, here we go. And I'll drop Nay's link to her website in the chat. All right, here we go. We're refreshing Mr. Jake's recollection currently, so we can't see what he's seeing.
Okay, is this something that has been marked as an exhibit that we can refer to for the record, or?
It is not, Your Honor.
All right, counsel, are you aware of what's being displayed to the witness?
Yes, Your Honor.
All right, go ahead.
For the record, Your Honor, I think our next number is 977. Mr. Firehelm, can you see that?
Yes.
If you would just review it and let us know when we can take it down.
Good morning, Kezchik. It's so good to see you. I know it's late where you are, but I'm glad you're here.
Okay.
So did Mr. Sabers and you discuss calling Mr. Krogman as a witness for Todd?
That was September 13th, I think. There was such a flurry of emails going back and forth. And I don't specifically recall that one, but I do now remember Bob bringing that up. And I don't know if we talked on the phone or just traded the emails about it.
And that would have been right before the trial started. Is that your recollection?
Yeah, just a few days before.
Okay. I want to move on a little bit here and ask, are you familiar with the field of biomechanical engineering?
No.
Do you
I know what it is, but
I'm sorry.
I'm sorry I interrupted you. I know what it is, but I'm certainly not an expert or that knowledgeable in it.
Did you consider consulting an expert in biomechanical engineering to investigate whether Amy could have sustained her injuries in a fall?
No.
As Letitia says, why come?
Did you consider or investigate the principles of force?
See, this part I don't understand. I do. Okay. I don't understand the why, but I do in a way. Okay. So, but I disagree with it. After reviewing the material sent through Discovery, Mr. Jake agreed with the medical examiner's assessment that it was indeed a homicide. So that's the route he chose to take. However, and I realize that he has a lot of experience as a trial attorney, right? And a defense attorney and stuff, a criminal defense attorney. But the fact of the matter is, or as No Sweat Andy says, the fat of the matter, the fat of the fatter, that's what he says. The fat of the fatter is that he's not a medical examiner. He's not a forensic, I shouldn't say medical examiner, but he's not one of those either. He's not a forensic pathologist. And because this was such a highly, highly unusual case, it would have behooved him to have someone else, specifically a forensic pathologist, review the material just to be sure. Also, speaking of that, I did stumble upon a video today, and it shows the injuries to Amy. And so I wanted to show you guys that. Don't let me forget, because I want you guys to be able to see what they're talking about. All right, here we go.
That could be generated from a fall versus a strike or a swing of the rake?
I did not.
I want to show you Exhibit 233, which we looked at yesterday. It's a letter from Mr. Mullis to you. I understand, I think it's undated.
I agree, Queen of Hearts. I do think he did a less than stellar job in
I can
this
see
case.
it, yes.
Okay, thank you. And if we can scroll, I think it starts on page 3 and 4. They're very small for me.
Violet says, behoove. I love a good
Did you
SAT
understand,
word in the morning. Me too.
Mr. Mullis, to be asking questions here about investigating a theory that Amy died from an accidental fall.
Certainly, that's what he's referencing there in the photos or the drawings that he made. But I don't know when. But without a date.
Would you agree that this would be a letter that Mr. Mullis sent you before trial?
Oh, yeah, yes.
And do you recall Mr. Mullis asking you to investigate how the far right tines did not come out of Amy's body?
I don't remember that specific question, no.
All right, if we could go to the first page, bottom paragraph. Could you review that for me?
Yes, Violet, that is Tristan. It is. Good morning, Tony. Good to see you, babe.
Okay.
It's
Would
been
you
a
agree
week,
that
hasn't it?
Mr. Mullis is asking you to verify the possibility of it being an accident.
That's what it says, yes.
And then on the second line, never truly, was totally out of the far right wound.
That's what it says.
Okay. Okay. So would it be fair to say that you weren't considering, the principles of physics or Newton's law of motion when you reviewed the autopsy report?
Excuse me, can you say that again?
Sure. Is it fair to say, based on your prior testimony, that you weren't considering the laws of physics or like Newton's law of motion when you reviewed Dr. Cruz's autopsy report?
No, I wasn't considering that type of technical analysis.
And because we're lawyers, that's why we would hire an expert.
Yes.
If you had had evidence before Mr. Mullis's trial that a swing of the corn rake could not have generated enough force, would you have presented that to the jury?
Well, I guess you start out if we had that. If evidence or witnesses are helpful to a case, of course you present it.
And if you had talked to an expert and that expert explained to you that the laws of physics made it impossible for the corn rake to have been swung into Ms. Mullis, would you have presented that to the jury?
Based on that hypothetical, yes.
If you had evidence that it was impossible for the corn rake to have been pushed or kicked into Ms. Mullis, would you have also presented that?
Same answer.
Did you present any evidence that Mrs. Mullis' death was the result of an accidental fall?
No.
And when Todd took the stand to testify, did you ask him any questions that would support that Ms. Mullis's death was the result of an accidental fall?
There may have been some questions about what he told law enforcement and medical people right after this happened, but I don't recall, I don't think there would be any other place in his testimony or I would have questioned about that.
Well, good morning, Margie. You're not super late, babe. We just really got into it. You haven't missed very much. We're just at the beginning of the testimony of Mr. Jake. You're doing just fine. You don't, I mean, if you feel like you need to get things together, far be it for me to tell you what you need to do, but you're not super late. All right, let's continue. It just seems like, okay, this is my whole issue with Mr. Jake as it pertains to the defense, okay, at the original trial. It seems like he just took the word of the medical examiner, okay, even though his client kept telling him, no, this is what happened. No, it was, she fell. It was an accident. And it's like, okay, so you didn't believe your client, right? You thought that it happened the way the medical examiner purported, right? Then why not put on evidence, especially if your client is adamant, vehement even, that it was an accident and he wasn't moving away from that, and you intend to call him to testify, then why didn't you present any evidence that supported the testimony he was about to give? I mean, you're asking a jury to believe the person who's on trial versus a licensed medical professional who is a forensic pathology. They've got, tons of education behind them, even though she was new, working independently or unsupervised in a sense as the forensic pathology for that county. She still has, that's her field of expertise. And I don't know another way to say this, and this might come out sounding kind of cold, but basically you put a farmer on the stand and he was expected to be the end all be all. And I don't understand that. I don't know what you were thinking. Why wouldn't you put on other witnesses that supported at least the friggin' testimony that your client was about to testify to? It baffles me. All right, here we go. And I'm sure somebody in the chat will know because I can't think right off the top of my head, but I seem to remember this gentleman was retained. He was a paid-for attorney. He's not a public defender. They were paying him for this, if I recall correctly.
Did you present any testimony or evidence about the prescription medications that Amy Mullis was taking at the time of her death?
I don't think so.
Did you consider or present any testimony or evidence that Amy Mullis was anemic at the time she died?
No, you didn't.
I don't think so. Todd may have testified about her being weak and dizzy.
Okay, so Queen of Hearts says, when he characterized his conversations with Todd as just ramblings of various possibilities of what could have happened, he lost me. Agreed. I mean, I appreciate his candor here and being forthright in, what happened, what he didn't do, all those things, right? Like, I appreciate that at least he's not testifying in sort of a defensive way, but let me rewind this because I had a point about what he just was at. Oh, the anemia. Again, Todd can testify to what he observed, right? But you should always have some type of witness that's going to bolster, back up, verify the information that your client is testifying to, because the jury is going to see the defendant on the stand, okay? And it's really hard for the average person who doesn't follow true crime or anything like that, right? Doesn't watch trials, anything, to understand, to not, or wait, let me put this back, to look at a defendant on the stand and listen to their testimony, but also keep in mind that they have a reason to be less than honest. They have a motive to lie. Their testimony is given with the understanding that the way that they testify, the things that they testify to, they have a stake in the outcome of the trial. He's the defendant, and they take that. I know that the jury takes that into consideration because they're people. People do that. That's how they weigh evidence. That's how they weigh testimony based on credibility. So you got to put somebody on the stand if your client is going to take the stand that bolsters the client's credibility. What are you doing, bro? And also this, Patricia says, whether one believes he is guilty or not, he definitely had ineffective counsel, 100%. Absolutely, I agree. Hey, Shauna, good morning. All right, I'm going to be quiet now because clearly I'm frustrated. Clearly I'm out of control. I can feel it. I can feel Spicy Jen waiting to emerge. So before that happens, let's continue.
When she was out in the barn helping get things cleaned up, but I don't remember if there was any specific evidence about any medical reports or evidence about her being anemic.
Do you recall in your opening statement telling the jury that Ms. Mullis was deliberately and viciously murdered?
Yes, you did.
I don't know if I used those words, but yes, that's what I was telling the jury.
Okay. I want to circle back to the text message evidence that was presented at trial. Do you remember there being text messages as a topic with quite a few witnesses?
Yes, I think so.
Do you recall there being witnesses who testified that Amy was unhappy or scared of Todd?
Yes.
Did you obtain copies of the full text messages or cell phone records for Amy and Todd Mullis?
I don't think we had 100% of the records. No, if that's what you're asking.
If we could show the witness Exhibit 307, the first 18 pages only. Mr. Fireholm, do you know if you've seen this document before?
The best answer I can give is I don't think so.
If there are text messages between Todd and Amy that contradicted what witnesses said at trial, would you have used those?
I'm not sure what you mean by contradict.
Would you characterize the state's evidence as attempting to, paint a picture of discord between Todd and Amy or tension?
Your Honor, I'm going to object on the grounds of 5403 and relevance. This evidence is not admissible, and so it's immaterial, but it's also a report that was generated by Mr. Castle and wasn't a part of the underlying record at the time Mr. Firehelm even represented them.
I guess, Ms. Nichols-Cook, did you want to respond to that?
Well, Your Honor, it's already admitted. I am not asking this witness to admit it. It's the whole point, right? He didn't have this information because he didn't request it, and he could have used it. to impeach the witnesses at trial that talked about messages with Amy that the state relied on.
Right. Kelly, can you read me back what the question was?
Would you characterize the state's evidence as attempting to, paint a picture of discord between Todd and Amy with tension?
Yeah. The objection's overruled.
Mr. Firehome, do you need the question again?
Please.
Did you understand the state's evidence at trial, or would you characterize it to be attempting to show that Todd and Amy were unhappy, or that there was tension in their marriage and in their home?
Yeah, I think that's fair.
So we're going to scroll down here. What page? Page 14. And I think I can direct you to line 233. And then 234 after it.
You need to scroll a little bit. I can't see 233. Okay.
Can you tell me what the dates are for line 233 and 234?
October 14th, 2018.
And this would have been shortly before Ms. Mullis passed away?
About a month.
And would you agree that the content of these messages contradict the state's narrative?
Yeah, those two do, yes.
Okay, we can take that one down. Mr. Firehome, did you take any steps to impeach or discredit the witnesses who testified at trial regarding Todd and Amy's relationship?
Well, I guess the record would speak for itself. I think we cross-examined them, but I don't recall specifically.
I'm sorry. Did you take any steps to determine if Amy Mullis had a Facebook account?
I don't remember.
Could it have been helpful to you to present evidence from Amy that her and Todd were happy?
Yeah, I suppose it could have been interesting or relevant to the jury, inconsistent with what was going on, but
So, Mr. Fairhelm, do you recall reviewing phone records from Terry Stainer?
I might have, but I don't think so.
Do you recall Terry Stainer's testimony at trial?
Not in any way I could talk about it today.
If I represented to you that the transcripts indicate that Terry Stainer was testifying about Amy being upset or scared of Todd, or that she testified about Amy saying, "Look for me in the timber," would you agree with that?
Yes, I think so.
If we can show the witness 372.
Right, Queen of Hearts? This is what I keep waiting for. Hold on. I keep waiting for him. I keep waiting for him to be like, fine, okay, hold on, where's it at? Let me find it. I was ineffective. Just stop already. You know, I keep waiting for him to say that, but okay, so Patricia says, WTF was he doing when he was getting paid to defend Todd? Jen, is it possible that Todd could be freed because of this? Okay, so let's play the different scenarios out, right? So the judge in this case is the only fact finder, and what they're asking for is a retrial, which essentially vacates. It doesn't essentially. It does vacate his prior conviction. Everything starts over again. So then it would be up at that point. It would be up to the state to decide whether or not they want to retry Todd Mullis. So in theory, yes, he could absolutely, if the state says, you know what, given what we've seen in this hearing, all right, we don't think that we can convince 12 jurors to find him guilty because there's evidence of potentially actual innocence in their minds, right? And there's definitely going to be some evidence should Dr. Hammers testify, should the biomedical engineer testify. There's going to be reasonable doubt, and they could say, we don't think we could convince 12 jurors all over again, and they could opt not to retry him. If that is the case, if those two things happen, one, he's granted a retrial which vacates his conviction, and the state chooses not to pursue charges against Todd and retry him again, then yes, he could absolutely be free. I have to say that.
Do you know if you've ever?
Hold on. I have to say, because it just bears repeating, that I'm a little put off by the amount of whispering that's going on at the defense table. And here's why. While it mainly for the purposes of this actual bench trial, it's not that big of a deal. But I hope that should he be granted a retrial and they intend to be the attorneys of record and handle that retrial, what I would hope is that they streamline this much better, because the jury they will lose the jury, particularly in the afternoon. Once lunch is had, you know, people are people, and when their bellies get full, people get sleepy. So you gotta, streamline it, ladies. Come on.
Seen this before, Mr. Firehome?
Best I could do is I don't think so.
And can you tell what it is?
It looks like phone records, and at the top it says David Stainer.
If these phone records would have impeached Terry Stainer, would you have used them at trial?
Sure.
If they would have discredited her about Amy coming to her house crying in October 15th, 2018, would you have impeached her with proof that Amy didn't?
Sure. Anytime you can discredit a witness, you try.
So
I
then
don't know how this would do that, but yes.
So then why didn't you do it? Why didn't you try to impeach any of these witnesses? I mean, really impeach them.
Okay, we can take that one down.
I don't mean impeach them by,
Mr. Fire.
Poking a little bit at cross-examination. I mean, really impeach them with evidence.
Do you remember a witness by the name of Corey Volker?
I don't recall that name.
You don't recall any investigation into Mr. Volker's relationship with Amy?
I'm not connecting that name with her, no.
Wow, Patricia. Patricia said, I ain't gonna lie. I ain't gonna tell a lie. I'm more uncertain of this conviction than I ever was of Casey Anthony. And Queen of Hearts says, the biomedical engineering doctor was outstanding. She is the Simone Biles of researching. Yeah, I mean, she did a fantastic job. I would just make the suggestion, though, that should there be a retrial granted, that they prepare her testimony or ask her questions, and, elicit layman's terms in her testimony so that the jury fully and completely grasps what she's testifying to. That's important. All right, here we go.
Do you recall having in discovery text messages between Amy and Corey Volker?
I'm not recognizing that name.
Would you be surprised to learn that Mr. Volker knew about Amy's affair with Jerry Frazier?
Again, without picturing him or linking him somehow, I'm at a loss here.
Ooh, this is a good question. So Sarah Bellum says, about 15 minutes behind. How is his attorney not believing him and looking into the accident different from Boone, insisting she was innocent? Just for the purposes of discussion. I get it. She said for argument, but I get what she's trying to say. All right. I'll tell you how it's different. Because Sarah Boone was insistent that she was innocent of second-degree murder, right? That all of this was a horrible accident. But at the end of the day, she never argued or claimed that she did not put him in that suitcase. So for Sarah Boone's attorney, right, that was really the crux. It was that this was an accident. And so that is kind of along the lines of what Owens was arguing in front of the jury, right? That Sarah was in the moment that all of this occurred, Sarah had a PTSD moment and kept him in the suitcase so that he couldn't get out and hurt her. And while that part of it was self-defense, the end result, which was George losing his life, that's not something that she intended. She only intended, according to Owens, this is his theory, this was his argument, she only intended for him to not come after her and be able to come after her in that moment. His argument was she had no idea that keeping George in that suitcase for that extended period of time would result in his death, thus making it some weird hybrid of self-defense and an accident. That's really what he was arguing. Whereas in this situation, what Todd was saying is there wasn't anybody else on the farm. Okay? I was there. Tristan was there. We saw the end result. And I'm telling you that this was an accident. And also I think with in this situation, yes, exactly right. Sarah says, I guess the fact that maybe they looked into it for Boone and the evidence didn't support it and bordered on unethical. So for Boone, what they looked into was the battered spouse theory or the battered spouse defense. And I think that, again, because Sarah Boone's attorneys had all of the evidence that all of the discovery material, so all of the evidence from the investigation, and there were those videos that Sarah Boone took herself that she mentioned in her own interrogation video as some sort of proof that George was the abuser, when all those videos actually showed was Sarah was. She just terrorized that man verbally, because they didn't show any evidence of her actually hitting him, but they did show a lot of verbal um, abuse. So I think that her attorneys felt like, should they go with the battered spouse defense, that Sarah didn't actually have battered spouse, and that Sarah must have wanted them to do something and represent the evidence a certain way, and they felt it was unethical because that it would have been a lie. An attorney cannot lie. So I think that's different, and I think that Violet, I felt like Owens was saying it was an oopsie daisy. We all knew Sarah was guilty. See, the thing about using the battered spouse defense is it's an affirmative defense. You're admitting that you took the life of somebody else, but there were extenuating circumstances. And therefore, you aren't guilty of second-degree murder, which they had other options, the jury did, as far as what they could convict her of. The problem was the evidence just didn't bear that out, quite frankly. Even the state's expert, even the defense's expert witness, even though the state's expert witness conceded that it was possible that Sarah Boone had battered spouse syndrome, right, in that moment. And that's what we're talking about here. In that moment. Not all 24 hours of that specific day, but in those moments, because it started out as a joke by Sarah's own testimony, then it couldn't have been a PTSD response. That was really the crux of the argument. It was very nuanced, and I thought that the state did a fantastic job. So, yeah, that's the big difference, I think, between this case and Boone's case, because even if, right, Sarah zipped him in that suitcase with only the thought of containing George, not thinking that this is dangerous and that he could die as a result of being zipped in that suitcase for, 12 hours, okay? She still has to be held accountable. Where Todd, his attorneys are saying this was not homicide at all. No other person caused the death of Amy Mullis. The corn rake caused her death. We're agreeing to that part of it. The corn rake was the tool. But this was simply a very, very unfortunate accident. That's the difference. We're talking about Sarah Boone claiming that his death was accidental, but she played a role in that death by zipping him in that suitcase. So she would still, even if the jury had found that Sarah didn't intentionally, which is why they said this is why she was charged with second degree, because, there wasn't any premeditation. But at the end of the day, that she's still going to have to be held accountable for that. I mean, it's just like when you get into a car and you are driving and you're impaired in some way, be that alcohol or a substance, right? Nobody intends to get into an accident. That's why they're called accidents. But at the end of the day, they hold that person responsible, because you shouldn't have been driving under the influence, impaired in any way, shape, or form. And so, but this is very different from that. They're saying their argument is there was no third party involved at all. This was just a horrible, horrible Final Destination level type of accident.
We can show the witness 268. So, Mr. Firehome, can you look at this and tell me what it is? To the best of your, I guess, ability to identify it.
It's SMS text messages. It says Corey Volker.
And have you ever seen this before?
I don't think so.
Okay.
Violet says the state did great. Kranick was great. Owens did what he was paid for while blocking cameras in the
we can
courtroom
get that
and
one.
forgetting to talk into the mic. You ain't never lied.
Do you remember there being witness testimony about Amy screaming and getting into a fight or being upset with Todd? Oh, looks like Mr. Firehome is frozen.
He's
Mr.
frozen.
Firehome, are you able to hear us?
Yes, I can.
Okay. It looks like your video is frozen.
I don't recall a screaming match between Amy and Todd, no.
Do you recall any text messages about Amy screamed?
I'm not recalling it today, no.
And did you do any investigation to determine the facts surrounding the text messages the state presented at trial?
No, I don't recall at this time.
Queen of Hearts says Owens was pretty good counsel. He had an unwinnable case. She was guilty, horribly and viciously evil. I have to say that Owens had a really he didn't have, I mean, he's not a bad attorney. Okay. He was highly effective, actually. I mean, he was quite competent, and he just, I mean, he had to take a shot, right? But at the end of the day, he started, and I think it's really important to remember this. I think Owens recognized what kind of case this was, which is why before there was even a discussion of him, or had considered representing Sarah, he did go up there and visit with her. But what he initially agreed to do first was be the intermediary between Sarah Boone and the state in negotiating a plea deal. And Sarah wouldn't have it. And he thought, well, I'm going to do the best I can do with the case that I've been given, the evidence that I've been given, and the time that I have to do it in. I'm going to try and get more time, but it is what it is. And I'm sure that we're going to see letters from Sarah. And I would imagine that Sarah is going to say she had ineffective assistance of counsel and tried to say it was because, he was limited, blah, 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 yada, yada, whatever. We have not heard the last of Sarah Catherine Boone. 10-10-7-7. So Violet says, Jen Liu of Todd is granted a new trial. Will this judge preside over it, or is she strictly presiding over the bench trial? She's an appellate judge, I believe. So no, she would not preside over a retrial. It would go back to the county where the charges originated from, and it would go back to circuit court, district court. Everything starts over again. It would be as if Todd was never tried in the first place. It's like that first trial never happened. It's a whole mulligan.
Mr. Firehome, you might want to turn your camera off and turn it back on. It looks like you're still frozen here, but we can't hear you.
Right now, I've lost that bar at the bottom where I can turn things on and off. All I have is that exhibit in front of me right now.
Oh, we've taken the exhibit down, so I am not sure what advice to give you.
Refresh your browser.
You see me now?
Yep.
Okay.
We're back. We talked a little bit yesterday about Todd asking you to have the accident theory investigated. Do you recall that?
Yes.
And I wanted to clarify if it was your testimony that Todd Mullis was just shotgunning, and if you could explain what that characterization means.
Well, Todd would write these long letters. Well, not all of them long, but there was a lot of it. And there'd be ideas or questions and so forth. And like I said, since I couldn't email him back, we would either when I went to see him at the jail or when we talked on the phone, we would address those things. And that's how I kind of interpret Todd told me and Bob, you know, I'm just sitting here, I'm thinking, I'm putting these things out there. That's kind of what I meant.
Okay, that helps.
I didn't mean what he was doing was inappropriate. It's just that's kind of the methodology that went on between the three of us.
Okay, so what he's testifying to, if I understand this correctly, is his characterization of what Todd was telling him was basically spitballing ideas. And what the defense is saying is this was him telling you what happened. This was not a suggestion. This wasn't like maybe this is what happened. He was telling you what actually happened. And this is where it's going to get tricky, because as we learned from Sarah Boone's trial, because Owen said this many times during the trial, it is the attorney's job to mount the defense, to decide what witnesses to put on, what to ask them. Yes, they take suggestions from their client, but ultimately it is the job of a criminal defense attorney to present the case in the way that they see is best for their client. And so we're going to be getting into some gray area here because, and this happens between people, right? This isn't like, you know, some weird, crazy, out of the way concept. Todd said it in a way or wrote it in a way, and it was the defense, or it was Mr. Jake's perception of what Todd was saying, where Todd says, hey, I'm telling you what happened. There's no question mark behind it. This isn't a suggestion. I'm telling you what happened that day. Please investigate it as an accident. That's what Todd says he said. But Mr. Jake's perception is that these were spitballing ideas. And that's a real gray area.
Do you recall answering Todd about whether the two tines ever came out of the right two wounds?
I don't remember that type of specificity. I don't think we did, no.
Good morning, Call Me Sadie. Call Me Sadie says, I still think he's guilty. But if he doesn't get a new trial, this judge needs to retire because it's not just ineffective counsel. Todd had no real defense representation. I would agree with that. I have not heard enough compelling evidence to support, for me in my mind, an actual innocence claim. Okay. But I will 100% agree with this is clear ineffective assistance of counsel. His conviction should be vacated. He should be given a retrial. Period. The end. Because this is why the appellate system exists in our country. It is a checks and balances system. And we, as citizens of the United States of America, have a constitutional right to a fair trial. And part of that fair trial is effective assistance of counsel. And this was not that. So I think if we let this go, or any case like this where there's clear ineffective assistance of counsel. And what I'm saying, and there's a difference between ineffective assistance of counsel and a Monday morning armchair quarterback, right? when you have a defense attorney who did not do any independent research or seek out expert witnesses to, at the very least, go over the evidence in this case and make sure that it's accurate, that it's correct. That's very, very different than you should have asked this question or you should have asked that question. That's what we're talking about here. You know, the shoulda, woulda, couldas. This is not that.
Would you say that Todd consistently asked you about evidence that Amy's death was the result of an accident?
Before he answers that, thank you, Shell, for becoming a member. I appreciate that very much. Thank you so much for supporting me and the channel. Thank you, thank you, thank you. Well, exactly. Hold on. Call Me Sadie says even Lori Psycho Vallo has an expert. Yes, she does. Yes, she does. Sarah says, thank you. Thanks for entertaining that. On the surface, the argument. Oh, excuse me. I didn't mean to burp in you guys' ear. Just kind of, pardon me. Thanks for entertaining that. On the surface, the argument seems similar, but the meat of it was very different. It helps put it into perspective via two very familiar cases to this group. Yes. Yeah. You're welcome. I hope I explained it well. All right, here we go. Let me rewind it because I don't even remember what the question was that he got asked.
Would the two tines ever came out of the right two wounds?
I don't remember that type of specificity. I don't think we did, no.
Would you say that Todd consistently asked you about evidence that Amy's death was the result of an accident?
Earlier on, yes, and maybe continuing for a while, but I don't think that was a big issue as we came down the stretch towards the trial.
Do you recall testifying in your deposition that Todd never stopped asking you to investigate whether it was an accident?
I don't recall that specific question, no.
We can. We will show you your deposition, Mr. Firehelm, just a moment here.
I have it here if you want to give me a page.
Yes, if you could turn to page 23 and look at line 5.
23?
Yes, page 23, line 5.
Okay, I see it.
And so in your deposition, you testified, no, Todd never stopped asking about experts in an accident theory?
That was my answer, that's correct.
Okay. I want to touch on communication with Mr. Mullis briefly.
And see, that's another issue. So why are you changing? I mean, we're in 2025. I think this deposition was in 2023. But at how do you remember in 2023 that he never stopped asking you, but then in 2024, you don't remember? Or you care, actually, it's not even that you don't remember, you characterize it in a completely different way. You say that he asked in the beginning, but as we got closer to trial, he stopped. Okay. That makes zero sense to me.
I believe you said you testified that Todd would call you from the jail before trial?
Yeah, I remember there were phone calls, yes.
Did you have concerns about the confidentiality of those phone calls?
I don't remember if the jail staff assured us that they would be confidential or not. I think they did. But I'll answer your question. No, I didn't have a concern.
So do you recall telling Todd that you couldn't say a whole lot on the calls when he would call you?
I don't remember that, no.
Do you know if you scheduled legal calls at either the Buchanan or Dubuque County jails?
I really, it would just be a wild guess. At Dubuque,
Hold on, before he answers this, it would just be a wild guess. As a criminal defense attorney, sir, would it not be standard operating procedure, protocol even, to establish that you are the attorney of record? And so any calls made by your client, an inmate incarcerated at whatever, Dubuque, whatever, wherever he was, that you would establish that with the phone carrier. They have a whole system for that so that you can establish yourself as the attorney of record and therefore the calls would be confidential. Come on, man. This is like basics. Basics. This is like when you're screen recording something, right? It should be standard operating procedure that you turn your phone to do not disturb. So that when you're making your if you're doing it on a phone, so that when you're doing a screen record, you're not getting bombarded with notifications in the middle of your screen recording. That's like screen recording rules that's like the first rule of screen recording. Oh boy.
we would have had to have done it in the evening, and I think I was there, pretty sure it was more than once. I know the night before the trial started, I went there on a Sunday night, but I think there were more than that.
I want to pivot now to your opening statement at this trial. Did you discuss that with your co-counsel, Mr. Sabers?
I think Mr. Sabers was there the night before the trial started. And whether or not we talked about the opening statement, I don't remember.
Do you normally?
Do you remember testifying in your deposition?
Hold on. Do you frequently consult with co-counsel respective to an opening statement? Is that something you do?
That you didn't give him a copy or a draft of your opening? Do you remember testifying in your deposition that you didn't give him a copy or a draft of your opening?
That would be accurate. I don't remember specifically in the deposition, but that would be true.
That night before trial began and you met with Mr. Mullis in the Dubuque County Jail, did you tell him what the substance of your opening statement was going to be?
I don't remember.
Okay, I want to pivot again. I'm sorry. I feel like I just keep jumping. You testified yesterday that you visited the Mullis farm, and I believe that you looked into the shed and kind of in the farmyard.
We went to the shed where this took place, and I don't think we went into the other buildings, but Lynn and Mike pointed out, I'm pretty sure Mike was there, what the other buildings were, and like there's the 2 hog barns, there's the machine shed, and so forth. And then I think it was just Lynn and I went in the house and sat and talked.
Do you recall taking any steps to learn what Amy was doing before her death in the hog barn?
What she was doing in the hog barn?
Right, before she went to the shed?
He must.
Just what Todd and Tristan testified to.
Right, because in his opening statements, he did say that she was cleaning fly fecal matter off of the lights in the barn.
And that's what Todd had told me in our conversations.
Do you recall there being injuries to Amy's right hand?
I don't recall specifically, no.
Do you recall doing any investigation to determine if they could have been caused by cleaning the light fixtures in the hog barn that morning?
There was no investigation as to that, and I don't remember Todd or Tristan saying that had happened. Todd said he was concerned about her balance and she was trying to do too much after this medical procedure.
So, Mr. Firehelm, I should have shown this to you yesterday, so I apologize, but this is demonstrative 275. I don't know for sure which camera I'm. Try not to cough. Do you know if you've ever seen this before? We're going to try another camera. Do you know if you ever saw this before?
I don't think so.
Did you ever consider if Amy was cleaning these and putting her hand in there that it could have created injuries on her hand?
Objection, speculation.
Sustained.
Did you ever consider if the hog barn light fixtures could have caused an injury to Amy Mullis's hand?
No.
Thank you. Thank you, Tom. Do you recall doing any investigation into farming accidents as a theory of defense?
No investigation into that, no.
Do you recall examining the corn rake that officer seized from the farm?
During the trial, yes.
But not before. Is that what you're telling me?
Yes.
Back the milk truck up. You didn't even look at the corn rake? Y'all, let me tell you something. I have looked at that dadgum corn rake, that specific corn rake, because that's really all that matters in this case, right? I've Googled a corn rake to see what a corn rake was. Okay. But you have to look at the actual corn rake in question, right? So I looked and inspected from photographs as best I could, right? This corn rake. I am a YouTuber covering this trial after the fact, obviously, right? This gentleman had the opportunity to inspect it visually, the actual corn rake in question, not from photographs, and go down to that shed. That's what I don't understand. Like, why? Let it go, Jen. Let it go. Don't be getting too out of control. Don't get too turned. It's not even noon. Yikes on bikes. Like, how do you not take measurements? How do you not look at the photographs of that shed taken by law enforcement and say, these aren't all that clear. Maybe I should, I don't know, gallivant on down and do a walkthrough with the video so that the jurors have an understanding of the size and the space.
So did you see the blood on the handle of the corn rake?
Not before the trial.
Did you take any investigative steps to determine how the blood would have gotten there or whose blood it was?
No.
Okay, and that's another thing. See, now if Todd's given a new trial, okay, at the end of the day, unless there was a video made when this happened, 2018, well, he wasn't actually even charged till 2019, but in 2019, if the defense had, if there's limited, things change over time, right? So things could have been moved in, moved out of that red barn or red shed, excuse me. And so that would change the area. And yet nobody, oh my gosh. Hey, Charlie, good to see you. So like, even if Todd's appellate attorneys went down in 2022, 2023 to take video of the inside of that shed, it would make no difference, because unless that thing was sealed like a time capsule for all time, nobody ever went in it, nobody ever, and there was no access to it. That's another thing. Like, you couldn't just say, oh, well, nobody uses this shed. No. You would have to be 100% sure that nobody could access the inside of that shed. So it would have had to have been preserved and secured in such a way that it looked exactly the same as it did around the time of the events, which is impossible because life doesn't work that way.
Do you recall Todd asking you in letters to look at the rake and the physical evidence?
I think he did, yes.
Did you ever look at Amy Mullis's clothing from November 10th, specifically the coat, the sweatshirt, and the long sleeve shirt that she was wearing when she was injured?
No.
Did you take any investigation into the holes in the clothing in relation to Amy's injuries on her body?
Well, when you say investigation, I mean, there were photographs in the reports that were made part of the discovery, but any specific investigation or having some independent person look at them and so forth, no.
Yeah, that's what she's asking. Was there we know that there was an investigation conducted by law enforcement. She's asking you about hold on, I'm about to cough. Hold on. She's asking you about an independent investigation, which I already know he answered at the very end there, but I had to get my outrage out. Charlie says, still going through a lot with my sister, Jen Lou. Sorry, I haven't been around. Well, you've been missed. I'm sorry to hear you're going through a lot with your sister. You know, I think about you too frequently, and you're never out of my thoughts and my prayers, babe, just so you know. Neat Noodle says, coming in late. I will send you a note from my mom. Morning, everyone. I'm going to need that note to be notarized as well. And I'm also going to need some kind of video statement from your mother, please, Nate Noodle, in order to give you an excused tardy. Otherwise, it's going to be unexcused. Just kidding. Can you imagine if I was like that, though? All right. So Violet says, does the Mullis family still operate the farm? Maybe Tristan or other family. You know what? That's a good question, and one that I don't know the answer to, but I'm going to try to find out. How about that? All right, here we go.
Did you take any steps to reconcile Dr. Cruz's opinion that the rake would have been swung 2 to 3 times, but there were only 4 holes in the coat?
No, I don't think so.
And Mr. Firehelm, are you looking at your deposition? I see you're looking down.
I have it right here in front of me, yes.
Okay. Do you recall looking into the security camera system at the Mullis farm?
There's either Mike or Lynn showed it, the one camera over in the machine shed, I think, that was not functioning.
Do you recall testimony from state witnesses that the security cameras were not working November 10th, 2018?
I don't know if they testified that all security cameras were, but the only one I remember there being concern or testimony about was that one, because I think it would have been directed towards the shed where this happened.
Do you recall Deputy Himsath testifying that the cameras had been turned off?
I think he did, yes.
If you had evidence that Todd was not on the farm when that happened, would you have presented it to impeach Deputy Himsath?
I'm not recalling Himsath's exact testimony about whether or not he thought Todd turned them off or when they got turned off. So I don't know how I would have used it.
Do you recall an inference that in committing murder, Todd would have turned the cameras off that the state was trying to make?
Well, yeah, I think they were trying to create whatever inference they could.
And if you could have rebutted that inference, would you have?
Sure.
Did you do any investigation to determine whether Amy Mullis or her boyfriend Jerry Frazier could have turned off their surveillance cameras to hide their affair?
No.
And you didn't consult any expert about the surveillance footage?
No.
And do you remember doing any investigation as to whether the camera lost signal versus things were deleted?
No.
I think yesterday we talked a little bit about hearsay objections and your motion in limine. Do you remember that?
Yes.
Did you know that by failing to make an objection during trial that you were waiving that issue for appeal?
Yes.
Did you have any discussions with Todd about waiving that appellate issue?
No, I don't think we did.
If the transcripts reflect that you didn't make any hearsay objections during the testimony of Terry Stainer, would you agree with that?
I think I would, yes.
Would the same be true then for Patricia Christopherson?
I think so.
Okay, so Call Me Sadie, our little factotum, has come with some facts. She says, I just read Jake's Google reviews. There were 9 reviews, and he got 4.9 out of 5 stars. One of them was for the person's third OWI. I forget what that stands for. Help me out. Also, I'm having a little bit of difficulty trying to, no matter how I Google the question with respect to what's going on with the Mullis farm, like who owns the Mullis farm, it continues to bring me up. Is that operating without a license? Is that OWI or OW? It is OWI. Okay, so operating while intoxicated. Thank you. We don't have that charge here in Texas. It's a DUI or a DWI. So but there might be a different charge if it's a boat. All right. Anyway, I'm having a difficult time, no matter how I Google, ascertaining who owns the hog farm currently.
And Carrie Callanan?
Yes.
Do you remember discussions with Mr. Sabers about seeking a change of venue for the trial?
Yes.
Let me start over. Was venue changed from Delaware County?
Thank you, Clicker, coming in clutch. Clicker says, farm still owned by Todd and Amy's trust, and yes, the family still farms it. Thank you. Thank you, thank you, thank you. Appreciate that, babe. Good to see you, too. Good morning.
Yes.
And where did it go?
Dubuque County.
Did you consider asking for an additional change of venue from Dubuque County?
I don't know if we considered filing another request. I think Bob actually maybe was the one that made the comment that we had gone from the frying pan into the fire as far as publicity and so forth.
Did you know if both Delaware County and Dubuque County share a media market?
Yeah, well, I know that from growing up, the Telegraph Herald comes out of Dubuque, the daily paper, and the Waterloo TV station cover, I think, both counties.
Do you recall expressing frustration to your co-counsel that a jury in Dubuque was not going to be any more neutral than one in Delaware?
I don't know if I said it or Bob said it or we both did, but that certainly.
Did you have any considerations about whether a jury in Dubuque would have a fair cross-section representation of jurors?
I don't know if that was a comment maybe made by the trial judge or by somebody in the room, so to speak, that it was just a more populated county than Delaware.
Do you remember considering or researching whether farmers are excused from jury duty in September due to harvest?
I didn't research it, but I've certainly had trials where farm chores and field work came up as an issue about whether or not a person stayed on the jury or not.
That's actually a really, really important point. I'm glad that she made it because ideally, right, who better to understand potentially Todd and his actions that he took that day, right, than other farmers. Like if you get me, a city gal, right, I'm not really that great of an example because to me, it seems like common sense that if you live in a rural community and you call and there's an emergency and you call 911, that it might be better and more efficient to try to head to the hospital yourself rather than wait for first responders to arrive. Okay. Obviously, that's for medical. Now, Yeah, I mean, I feel like to me, that makes common sense. To me, that's common sense. It doesn't mean anything one way or the other. You can see it as, oh, well, it isn't like uh, there were witnesses on that road from the Mullis farm to the route driven to the hospital where they said that they saw like Diane Downs. Yes, I'm looking at you, who was driving like 6 miles an hour. She wasn't in any rush to get her kids to the hospital. It's not like there was testimony like that. So, I mean, to me, it seems like um, Todd was trying to get her help. And he does sound on the phone from the 911 call while he's performing chest compressions. He sounds like he's performing chest compressions, unlike, yes, Boone, I'm looking at you, who sounded like she wasn't doing anything but counting along and puffing on a cigarette, which I'm not even judging her for being a smoker. Obviously, that would be very hypocritical of me. What I am judging her for is pretending to give CPR when she wasn't. Because and I'm going to leave it there. All right, let's keep going.
Do you remember any investigation or research into what kinds of jurors you thought could be fair and impartial?
I just relied on my experience.
Do you recall investigating whether Todd was planting crops or harvesting at the time of any of the Google searches that the state attributed to him?
Well, I know certainly Todd told us that, which I think was confirmed by Mike or Lynn or both.
Right. You relied solely on your client, right? So if you believed him when he was telling you those things, why didn't you believe him when he was telling you that it was an accident, and at least do some independent investigation or prepare or have a digital forensic expert review material so that at the bare minimum, they would be able to bolster Todd's testimony on the stand that there were some searches that were completely not him, like prom dresses, etc. He absolutely didn't do that. But those aren't the ones that were really, the jury doesn't give rat's fat kneecap about those. Those weren't the damning searches. Why didn't you get an independent forensic digital expert to say, I did the same download, I looked at the material, this is what my conclusions are, and they support Todd's version of events, that he was planting stuff on the farm when those searches were done, and therefore they were not done by him, and they had nothing to do with the way he felt or didn't feel about his wife, Amy. I mean, come on, bro.
Did you do any investigation or seek any documents that would have confirmed Todd was operating the planter in April and May of 2018 during these questionable Google searches?
No, I don't think so.
Are you familiar with the Farm Acre book and farm insurance?
Familiar with what?
Objection to misrepresentation of the characterization of those Google searches. They were not questionable. They were damning. I know you can't say that in court. That's why I'm objecting where it does no good. Because I can recall when I first started covering this bench trial, people coming in the chat, and one of their biggest issues was those searches. That is all.
A Farm Acre book and the concept of farm insurance? Crop insurance, I'm sorry.
No, I'm not.
If you could have produced evidence that Todd did not have access to the iPad or the internet on the dates of those searches, would you have presented that at trial?
Yeah, sure.
Do you recall telling the court that you had a family issue come up during this trial?
Yes.
And would that have been distracting to you?
It was concerning, yes.
I want to talk a little bit about Jerry Frazier and your references to him or your plan with regards to evidence about Jerry Frazier. Do you remember who he is?
Yes?
Do you recall in your deposition explaining that you were going to point to him as a possible perpetrator that was part of your plan?
Yeah, I think so.
Did you have any evidence that supported that Jerry Frazier had come onto the Mullis farm November 10th and attacked Amy?
I don't recall that.
Do you recall deposing Jerry Frazier?
Yes?
Do you recall whether he had an alibi for the time that she was injured?
I believe he did.
Did you have any other evidence that you were going to present at trial that supported Jerry Frazier being the perpetrator?
Nothing other than his relationship with Amy.
Did you have any other evidence to present that someone else was on the farm that day?
No.
Do you recall your closing argument?
Not really. Not any specifics.
Do you recall arguing that it was a murder mystery?
I might have said that. I don't know.
Would you defer to the transcript?
Yes.
Have you ever challenged chain of custody or contamination of evidence in a criminal case?
Yes.
In your representation of Mr. Mullis, did you investigate how the corn rake was handled by law enforcement?
I don't recall doing that, no.
Do you recall considering whether additional forensic testing of the rake could be helpful to you?
I don't recall considering that, no.
Can I have just a moment, Your Honor? I think I might be done.
You can.
I'm going to step away and lock my front door so we don't get interrupted.
Okay, thank you. Mr. Firehome, my last question. Do you remember there ever being a time that Todd Mullis agreed with you that Amy's death was a homicide?
I don't think he ever said those words, no.
Nothing further from the applicant, Your Honor.
Cross-examination, Mr. Duden?
Yes, Your Honor, but I wonder if now's maybe a good time to take an opportunity for a bathroom break and to reset. If possible, we could take like a 10, 15-minute recess, if that's okay.
We certainly can. Let's go ahead and take about 15 minutes. We'll plan on picking up at 2:25. Mr. Firehelm, I will just leave the Zoom on so you can stay logged in, and everything should hopefully still be operational when we come back. Court's in recess until then.
Sorry, I was having a brief sidebar with my little chicky nuggy pot pie Esquire. I don't remember, Charlie, but that is a really good question. And you came in I don't know if you were in here when I said this, but I intend, because one of the people who comes into the chat quite frequently, emailed me with some notes of things to sort of like put together as like a recap or whatever, a better explanation of things that we've seen in this trial. Hang on just one second. I don't know if I muted in time for that because I tried to prevent the burp from coming out. But anyway, sometimes coffee does that to me, so please excuse me. That is a good thing, and I will include that in that video because I think that's important to know how long the jury was out. If I remember correctly, and I watched this when I covered this trial initially. I covered it after the fact, and I covered it with criminality. And so we sort of we weren't waiting for a verdict if we had done it when it was live. So I'm gonna have to go back and look into that because I'm kind of curious. All right, so let's hear what the cross-examination is, and it is going to be, I think, a fairly substantial cross. And I see that they're putting up some of the letters, so I'll try to read those for you guys so you guys can see them or hear them. And then after we're finished with the cross-examination, we're going to rewind and listen to the first part of today. I just skipped in order for continuity because I need to hear it all at once.
Probably in March.
Let me rewind.
I would agree that you represent, for or rape, for instance, as well as sex abuse and things like that as well, yes?
Correct.
So you have a wide array of experience for high-level felonies and trying those cases. Is that fair?
Yes.
So turning your attention to this case specifically, it's fair to say, I think at this point, you would agree that you represented Todd Mullis in this case, right?
Correct.
When did you begin representing Mr. Mullis?
Probably in March of 2019, I think.
If I told you that I believe you appeared in the case around March 8th of 2019, is that right?
That sounds right.
And so you appeared shortly after the criminal complaint alleging that he had committed murder in the first degree was filed, right?
Correct.
As you mentioned on direct examination yesterday, I believe you said that you were referred to this case in order to assist Mr. Sabers. Is that fair?
Yes.
Why did Mr. Sabers need assistance what was your understanding?
That he did not have jury trial experience at this level of offense.
And so it's fair to say that your experience would be an aid to both Mr. Mullis and Mr. Sabers in trying the case. Is that right?
Yes.
But you did not outright assume the case. You first met with Mr. Mullis' family. Is that fair?
Yes.
That included his sister and brother, I believe, right?
Yes.
And at that time, you talked about the case, right?
Yes.
You also viewed and inspected the property where the murder occurred, right?
Correct.
Is it safe to say that after you drove from I believe your office is based in Des Moines, to Delaware County, that you spent a sufficient or extended period of time discussing the case before taking on any representative role?
Yes.
Did you also speak with Mr. Sabers before assuming the role of counsel in this case?
Yes.
And of course, did you also speak at length with Mr. Mullis?
Yes.
So ultimately, you appeared in the case, but by that point, you'd spoken to multiple people about the facts and circumstances surrounding Amy Mullis' death and Mr. Mullis' charges, right?
Yes.
At all times during your representation, taking it from a big approach or kind of a macro approach before we go to a micro level, you maintained that Mr. Mullis was innocent and did not murder his wife, didn't you?
That's correct.
So at no point in time did you encourage Mr. Mullis to plead guilty. Is that fair?
Yes, that's very fair.
At no point did you encourage him to plead to a lesser offense level or level of murder or manslaughter, for instance?
No, sir.
So at all periods of time, I believe, is it safe to say that you believed Mr. Mullis was innocent?
That's correct.
And that's what you held out to the jury over the course of this trial in this case, correct?
That is correct.
So in your investigative steps, as we kind of work our way up towards the trial, again, you interviewed Mr. Mullis' family, yes?
Yes.
And you regularly kept in contact, in fact, with Mr. Mullis' siblings, who were assisting in providing information and conveying information between you, Mr. Sabers, and Mr. Mullis, who was very active in his case's defense, right?
That would be correct.
You reviewed letters,
Yes.
took phone calls, is that right?
Yes.
Not just from Mr. Mullis, but also from his siblings or family.
Yes.
And in this period of time of about 6 months, it was not just at the beginning that you took these steps, but you followed that all the way through to trial as well, correct?
Yes.
Now, directing your attention to what has previously been marked and admitted as State's Exhibit F in this case, I believe Mr. Bakke is going to put it on the screen for you, if that helps as well.
I have it in front of me.
Perfect. Well, we'll jump right in then. Do you see the email correspondence marked as Exhibit F on your screen as well?
Yes.
All right, let me go over to my phone and because there's a little tiny delay between, oh wait, no, hold on. All right, let me close the chat and make it big so I can see if I can read it to you. Let me see. Oh, this is really bad. Hold on a minute. I wonder. Ugh. That's the best I can get it. Oh, this is really, really hard to read on a pause. Let me see if it.
Now, would you agree that this is an
There's
April 6th, 2019 email from you to your co-counsel in this case, Mr. Sabers?
Correct.
In directing your attention specifically to what is the first paragraph, let me know if I read this correctly. After again reviewing.
Wow, Jenna, you could have just waited. He's going to read it to you, but I'm going to read the whole thing because what if he doesn't read the whole thing? He just wants to read a specific part. So, okay, here we go. After again reviewing the medical examiner's report and the photos we do have, I am almost certain that her death was not a result of accidentally falling on the fork. The number of puncture wounds, the fact that she had several layers of clothing on, the abrasions on her chin/jaw, abrasions on her hands that I will bet will be described as defensive wounds, all lead me to conclude it was a homicide. I expect we would need to have our expert take a look at the state's examiner's work, but I would be surprised if he disagrees. Our money may be better spent on getting a good private investigator involved. I don't know how well the scene was examined by law enforcement, and with the passage of time, any investigation by a forensic examiner now may be quite limited in what we could find out, what could be found, and how reliable findings would be. I suggest we focus on deposing those who were first on the scene so we can determine where to go from there. There may be two theories of defense. One is that Tristan is our alibi witness that proves Todd could not have committed the murder. As far as I can tell so far, he has been very consistent in what he says happens. The state, of course, would want the jury to discredit his testimony due to his relationship with Todd, but in my experience, it is hard for anyone, especially a young one, to come up with a false story and be able to be consistent. The second theory we would incorporate, number one, is TODDI. The other dude did it, which would dig into her, I think, affairs and who those were with. Okay, here we go.
Doing the medical examiner's report, in the photos we do have, I'm almost certain that her death was not a result of accidentally falling on the fork. The number of puncture wounds, the fact that she had several layers of clothing on, the abrasions on her chin/jaw, abrasions on her hands that I will bet will be described as defensive wounds, all lead me to conclude it was a homicide. Did I read that correctly?
You did.
So, less than a month after you appeared in this case, and the trial information was filed, this email would suggest that you believe that this was a murder, in fact. Is that fair?
Yes.
And you conveyed that to your co-counsel, right?
I did.
But this wasn't the last time that you conveyed to Mr. Mullis or even anyone interested in the case from Mr. Mullis' side, including Mr. Sabers, that you believe this was a homicide, correct?
That is correct.
Is it safe to say that you conveyed that you believe this was a murder with some regularity?
Yes.
To your knowledge, and based upon the notes, do you believe that Mr. Mullis was not supportive of proceeding with that avenue of defense at trial? Put another way, did you have any indication Mr. Mullis was not comfortable with you conceding this was a murder, but that it wasn't him?
I believe he conceded that.
That you were empowered or permitted to go to trial and argue that this was a murder case?
Objection misstates the prior testimony today.
Overruled. The witness can answer.
Could you ask that again, please?
Is it possible to read it back? I apologize.
That you were empowered or permitted to go to trial and argue that this was a murder case.
Could you hear that, Mr. Firearm?
No.
Oh, so I believe the question was, so you were, in your mind, empowered or permitted to concede at trial that this was, in fact, a murder, right?
Correct.
To your recollection, do you have any knowledge?
Hold on. I got to stop right there. I wanted to hear that answer because I thought that was, I have to be fair. I thought that was a really good question by the state because this is what it really comes down to. This is the crux. And this is why it's so difficult to mount a successful ineffective assistance of counsel appeal because it's all going to come down to what the defense attorney, Mr. Jake in this case, believed he was authorized to do. And so if the judge believes that Mr. Jake, that she takes Mr. Jake's testimony at face value, where, and I'll remember, we have not been able to read yet Todd Mullis's letters, so my opinion could change. Okay, but if well, I'll just leave it there just for a second. Okay, so if the judge who's listening to this testimony believes that Mr. Jake is testifying accurately and honestly about what he believed at the time, which was that he was authorized and permitted and the defendant was on board with presenting this case as the other dude did it, then it's going to be very difficult from there to be successful in getting an ineffective assistance of counsel appeal.
Knowledge or recollection of Mr. Mullis telling you that you needed to
Hold on, let me rewind that because I want to start at the beginning of his question. Give me just a sec.
empowered or permitted to concede at trial that this was in fact a murder, right?
Correct.
To your recollection, do you have any knowledge or recollection of Mr. Mullis telling you that you needed to correct your opening statement during questioning or the examination of witnesses?
No.
To your knowledge or recollection, do you believe that Mr. Mullis ever told you not to again say that they believe this was a murder in its closing?
No.
And do you recall that Mr. Mullis himself agreed that this was a murder on cross-examination at trial?
I believe he did.
So is it safe to say that it was undisputed that this was a murder and not an accident during the trial proceeding?
I'm going to object and ask, the question is vague. Undisputed by who? Maybe would help.
Mr. Duden, did you wish to clarify your question?
Sure. So is it your understanding that you, your co-counsel, and Mr. Mullis agreed at the time of trial and throughout that this was a murder case?
Go ahead. Continue to renew my objection. I don't think this witness can testify as to what Mr. Mullis agreed or what Mr. Sabers thought.
Overruled.
I don't recall either of them disputing or arguing with me about that approach.
And to be fair, as you said earlier, Mr. Sabers, in your opinion, lacked the experience in order to be able to try this case, so you became lead counsel, right?
Correct.
Mr. Sabers did not examine any witnesses at trial, right?
He did not.
He didn't do an opening statement,
No.
nor did he do a closing argument, did he?
No.
So at all points during the trial proceeding, you were representing Mr. Mullis.
Yes.
Now, looking back at State's Exhibit F specifically, I'd like to direct your attention to what is paragraph 2, where you say, quote, I expect we would need to have our expert take a look at the State's examiner's work, but I'd be surprised if he disagrees. Our money may be better spent on getting a good private investigator involved, close quote. Did I read that correctly?
Yes, you did.
So even early on in your representation, you were considering hiring medical experts, weren't you?
Yes,
And you were considering hiring private investigators, right?
correct.
And you were going to investigate this case with the help of experts if it was necessary, weren't you?
That's correct.
But is it fair to say that during the course of your investigation, in your professional opinion with 45 years worth of experience now, that you didn't believe those experts were needed?
That was my conclusion.
Looking to the course of your investigation, you did, however, look at all of the law enforcement reports in this case, didn't you?
Everything that was provided, yes.
You reviewed transcripts of witness statements, right?
Yes,
You received and reviewed audio recordings or video footage when it became available to you, yes?
correct.
And you conducted depositions, right?
Yes,
Before those depositions came to be, though, you also looked at this case from the perspective of electronic evidence, right?
yes,
You actually reviewed Cellbrite phone data, or Cellbrite phone dump, for lack of a better term, that was provided to you by DCI and by the Delaware County Sheriff's Office, yes?
I believe so.
That information included a review of things like the iPad in this case, right?
Yes, it did.
As well as phone records when it was necessary or relevant, yes?
Yes,
And again, you reviewed all of that information.
yes,
Looking to your depositions here, I believe you conducted around 16 depositions of potential state witnesses before trial, right? Around that number?
that sounds about right.
You conducted depositions of lead investigator, for instance, Special Agent Turbot.
Yes,
And if you recall, when you deposed Special Agent Turbot, you did so with the view that you're also going to ask about potential other suspects in the case, right?
I think so, yes.
And is it fair to say that during that deposition, you also asked about a potential affair between Amy Mullis and sheriff's deputies from the Delaware County Sheriff's Office?
I think we got into that, yes.
And so now that individual's name, I believe you know to be Rowley as a last name, as well as potentially others, right?
I think that's right, yes.
And do you have any reason to doubt that in Special Agent Turbot's notes, he referred to Rowley as Raleigh with an A instead of an O? Does that sound or ring a bell to you?
Yeah, it kind of does ring a bell, yes.
And in fact, you asked about those circumstances in that report when you deposed him, fair?
Yes,
Drawing your attention to what's previously been marked as State's Exhibit G, do you have that exhibit in front of you, Mr. Firehelm?
I do.
And to be clear, would you agree that this is a chain email or correspondence between you and your co-counsel, Mr. Sabers?
Yes,
And would you agree that both of the messages depicted here fell or came from, were sent on Thursday, April 4th, 2019?
yes,
So starting with your message, which is the smaller paragraph section on the second half of the page,
We will not be starting with that because we'd like to know all of the things. So let me rewind just briefly. Okay. This is Bob Saber's reply. I haven't sent it to the expert yet, but will shortly. They apparently didn't give us the photos they took of Todd's body 5 days later pursuant to a warrant. But Todd says he didn't have any cuts or bruising other than maybe a minor cut or two incidental to farming. Todd told me that aside from the family's interaction with each other, Jerry was the person they saw more than anyone else. Todd says he believed Jerry when he denied romantic involvement with Amy. He says Jerry was very persuasive. He'd probably be able to fool law enforcement if he's that good. Or how about Jerry's wife, or the sheriff's deputy, or Tristan? There's a couple of rumors out there in regard to the death of a guy from Manchester. He froze to death after driving off of a rural road when we had the bitter cold weather in late January, early February. The rumors are that the guy was sleeping with Amy, and either the deputy who had the affair with Amy or Todd ran him off the road. I'm sure there's no truth to that rumor, but had Amy reignited something with one of the deputies she previously slept with? Who better to frame somebody than a law enforcement officer? I spoke to Lynn about returning an iPod of hers that she previously left at my office and then taking another gander at the red shed. I love the word gander. Her mother thinks there's something in there that has been missed. She's having dreams to that effect. I doubt that investigators did anything by way of looking for DNA in there, and by now, I suppose the scene is compromised. In my prior musings, I concluded that eventually finding fault with the shortcomings of their investigation would eventually be the route to follow as opposed to hiring someone to process the scene. That mark on Amy's chin looks like she went down on something like the auger. All right, let's keep going.
Starting with your message, which is the smaller paragraph section on the second half of the page, you wrote to Mr. Sabers that you expressed concerns about irregular injury patterns.
So his reply is, okay, making sure you guys can hear me. Bob, I have a lot of concerns similar to yours. In addition to the irregular patterns of injury, she has marks on her hands, arms, and the larger abrasion under her chin/jaw. I realize one bruise on her arm is from an IV site from her medical procedure a few days earlier, but there are others that I'm betting the state will claim as defensive injuries sustained while she tried to ward off blows. As I drove back from my meeting with Todd yesterday, I wondered to myself whether someone other than Todd did murder her. I only skimmed some of the statements contained in the numerous reports where Amy shared her extramarital affairs. Is it possible one of her interests felt she needed to Is it possible one of her interests felt the need to shut her up? From the statement taken from Amy's girlfriend, Patricia Christofferson, Amy's relationship with Jerry was very intense. They contemplated marriage after each divorce. At one point, Todd called Jerry's wife, but I am not certain I know why and the outcome. That may be in other documents I haven't gotten to yet.
Marks on the hands and arms, the large abrasion on Amy Mullis's chin or jaw. Those are one of the concerns you shared, right?
Yes.
You also mentioned that you had reviewed at least her medical information and the specifics about a bruise on her arm that was from an IV site from a medical procedure she had days before she died, right?
Yes.
So you had accounted by this point for her various injuries that led to her cause of death.
Yes.
And again, this is when you also were evaluating the potential claim of defensive wounds or injuries that were not from the puncture wounds to her back from the corn rake.
Correct.
This also notes that you went to go visit Mr. Mullis in person, right?
Yes.
And if you go to the third paragraph, it also shows that you reviewed the statements taken by individuals that you were asked about on direct, including Patricia Christofferson, right?
Yes.
And an individual by the name of Jerry, who ultimately was a subject of the case, or Jerry Frazier, is what you came to understand, right?
Yes.
So at this point, is it safe to say you were looking at this case from other potential suspects, right?
Yes.
And matters that of what happened months before even this case began.
Yes.
And so you knew about people who were supportive of Amy Mullis, for instance, or her friends in their statements, right?
Yes.
And you knew that they would potentially testify in this case too. Fair?
Yes.
If you flip to the second page of State's Exhibit G as well, there's a message dated also from April 4th there from your co-counsel, Mr. Sabers, directed towards you as well, correct?
Yes.
And in that message, you also discuss the autopsy report and accompanying photos, correct?
Correct.
And you even discuss down to the depth or distance between certain wounds, correct?
Yes.
Okay, this is, have you forwarded the medical examiner's report to our expert? Thanks, Jake. From Bob, what do you make of the autopsy and accompanying photos? The medical examiner doesn't state that she believes the corn rake was what caused Amy's wounds, just that she died of sharp force injuries. The corn rake tines are 3 inches apart, and her wounds don't appear to be evenly spaced 3 inches apart or even close to 3 inches apart. Some are closer than 3 inches apart, and some are further than 3 inches apart, and they're not in a straight line. Is there any significance to the fact that the ME says the puncture wounds range from 1/8 inches to 3/8 inches? Close-up photos of the tines don't show blood on the tines. The tines don't appear to be very sharp either.
And as we noted from your prior message, you shared a lot of these concerns, but these would potentially come to fruition to say that there was potentially more than one strike or swing, I think is how it was referred to on direct, right?
Yes.
I'm sorry, can I, objection, what portion of G are you looking at?
The page 2, the full
What is
paragraph of
it,
text.
what line says swipe or swing?
Oh, that was a paraphrase, a characterization used from the direct examination testimony, Your Honor.
I'm going to object to the characterization of swipe because I don't think that word was used.
Okay, I guess the record will speak for itself. We'll move forward with a new question, I believe, at this point, unless there was one pending.
Okay.
Mr. Duden, did you think you had a question pending?
Possibly, maybe, I don't know. I can ask another question.
All right, let's do that.
When we had discussed a swipe or a swing, for instance, what we're really referring to is the puncture wounds, right?
Correct.
And those would be known as the 6 wounds caused by the corn rake to the back of Amy Mullis' body.
Yes.
Looking to the responsive message from Mr. Sabers to you on page 1, that big block of text, do you see that?
Yes.
And in this text, if you'd like to review it, you also noted, you substantially discuss Jerry, right?
Yes.
And the other individuals, including a possible sheriff's deputy who Amy Mullis would have had an affair with, right?
Yes.
So is it safe to say that even at the earliest point of this case, you were considering other people who could have murdered Amy Mullis?
Yeah, this was very early on, beginning of April.
I would be remiss if I didn't point out that while it's very clear, I have to agree from the evidence in these emails, right, that I don't dispute this with the state, that they were intending to present an alternate suspect. That's fine. There's nothing wrong with that. I'm not even arguing that. What I'm saying is, why, if that was the intent, if that was the plan for trial, why then did you not do anything prior to trial to investigate this theory of alternate suspect? It would be different if you didn't, if, for example, the defense is never required to present a case. The burden of proof is solely on the state. However, you had your client testify. Again, I go back to saying this, like, I feel like I've said this at least 11 billion times, right? If you intended to present a theory of an alternate suspect, surely you are aware that the jury would expect to see evidence of an alternate suspect. And your main alternate suspect seemingly has a whole ass alibi. So why would you then think it would be a good idea to present the theory of an alternate suspect using only Jerry Frazier as your alternate suspect? And if you were going to leave it ambiguous, look, we're saying she was murdered, but Todd is not the one that did it, then why not present evidence of how long it would take the average, a man like Todd, how far of a distance it is, not aerial views, because those are deceiving. Actual measurements of the distance between the hog farm or the hog barn, excuse me, the whole place was a hog farm, the hog barn and the red shed. And reiterate how long Tristan says he was out of the hog barn in an adjoining little area of the hog barn, out of the part where the hogs are at, how long he was out, how long he was in that room and didn't have a total constant view of his father. It was a very brief amount of time. So something to bolster a theory that you presented at trial.
If you look down as well, you let me know when you see the information regarding the DNA evidence.
I see it.
In the individual at the latter third or so of that block of text, it says, quote, "I doubt that investigators did anything by way of looking for DNA in there. And by now I suppose the scene is compromised." Close quote. Did I read that correctly?
You did.
So at this point, you were also considering scene integrity, fair?
Oh, yes.
And you were considering the avenues of possibly a faulty investigation or a less than thorough investigation. Is that fair?
Sure.
Which is things that you brought up at trial, actually, right?
Yes.
And again, continuing on there, Mr. Sabers came on the case before you, correct?
Yes.
And at that next sentence, he says to you, quote, "In my prior musings, I concluded that eventually finding fault with the shortcomings of their investigation would eventually be the route to follow, as opposed to hiring someone else to process the scene," right?
Yes.
Hey, Tosh says, "I've been here all the days Miss Lou has been streaming. I've just been lurking in the shadows. This is an insane case. I can't tell how I feel." Well, thank you for coming out of the shadows, but also thank you for watching every single day. Thank you. I appreciate that. All of you guys. I do. I appreciate that. By the way, speaking of, you hit that thumbs up yet? Come on, y'all. Do your girls solid. This is a very unusual case. I have to concede that this is not, this is unlike any case I've ever tried before or covered before, in that the instrument that caused Amy Mullis's death is a corn rake. This is the first I've seen accidents. I've covered cases where crimes were staged. Crime scenes were, well, let me say that like this. I've covered cases where scenes were staged to make it appear as an accident when in fact there was actually a crime committed. But never like this. Never where there are so many unanswered questions.
So when we talk about processing the scene, we're really talking about evaluating the scene for alternative theories or looking for additional evidence, right?
Correct.
And so at this point, you and your co-counsel had considered this as a choice, right?
We did.
And so things like an accident reconstructionist, for instance, or an evaluation probably wouldn't have been on your mind as viable avenues for the defense.
It was not.
Now, you were asked about a biomechanical engineer specifically, weren't you?
Yes.
Oh, and I'm sorry, I do just want to talk about, there was one more sentence that I figured I'd go ahead and cover with State's Exhibit G. The last sentence of Mr. Sabers' reply to you reads, quote, "That mark on Amy's chin looks like she went down onto something like the auger," close quote. Did I read that correctly?
You did.
So you knew about a potential avenue of whether or not the auger was involved in causing Amy's injuries.
Yes.
And you also knew or were considering whether or not the fall to, or the mark on Amy's chin was due to a fall injury, right?
Yes.
But it's fair to say, like before, you didn't believe that a fall was a viable avenue or claim, right?
That's correct.
And that's with more than 4 decades worth of experience predominantly focused in criminal defense, right?
Yes.
So again, returning to the discussion of a biomechanical engineer, have you ever worked with a biomechanical engineer?
I don't think I ever did with someone that had that exact title, no.
And so, have you ever heard of a case in the state of Iowa, where a criminal case in the state of Iowa, where a biomedical or biomechanical engineer would provide testimony?
Sure, I read all the appellate decisions and belong to IAJ where we trade information like that.
So being aware of their work and the type of work that a biomechanical or biomedical engineer would do, you knew of that, right?
Sure.
And based on your experience and judgment, you did not believe that it was a viable avenue to do a scene reconstruction, for instance, here, right?
I did not. That's correct.
But looking to State's Exhibit H now, you and your co-counsel, again, were considering potential expert testimony in this case, right?
Yes.
In fact, you considered having the medical evidence reviewed by maybe an independent medical examiner or an expert witness in your case, right?
Yes.
Looking to what is the May 2nd, 2019 email message between you and your co-counsel, Mr. Sabers, do you see the message with the title subject being R.E. Bond?
Yes.
That first paragraph says, quote, "We can and probably should have the autopsy report reviewed, regardless of our opinion that it was not an accident." Did I read that correctly?
You did.
So in this instance, you were also considering it from the perspective of whether an accident was potentially viable.
Yes.
And is it safe to say that that claim was coming from things Mr. Mullis had told you, as well as potentially his family or support system?
It was, yes.
But as your investigation progressed, the medical information didn't seem to be necessary for you to retain your own expert, correct?
That was our conclusion, yes.
Is it fair to say, based upon the number of times you discussed it, that you actually did contemplate or research reaching out to an expert?
Sure.
And that avenue was either not proceeded with or was otherwise fruitless, right?
That was the conclusion.
Early on in the case, though, as you mentioned, I believe, or at least in your prior notes, that a bond review or lowering Mr. Mullis' bond was a primary focus at the start of the case, right?
Correct.
You spent a significant amount of work on attempting to lower Mr. Mullis' bond, right?
Yes.
In fact, you even filed for an interlocutory review or an interlocutory appeal to have the Supreme Court attempt to allow you to lower his bond, right?
Yes.
And this was noted to be a significant concern for Mr. Mullis, wasn't it?
He was extremely stressed about being in jail.
In your interactions with Mr. Mullis, he regularly was stressed about either being in a jail setting or incarcerated or the case, right?
He was, yes.
In looking down to the next message on State's Exhibit H, which was from your co-counsel to you, sent on May 1st, 2019, do you see that?
Yes.
In this message, based on your review, is it fair to say that Mr. Sabers or yourself had provided Mr. Mullis with the reports of law enforcement officers or investigators in this case?
I think Bob took those to him, yes.
And in fact, you and Mr. Sabers had expressed your questions or attempted to answer his questions too, right?
So let me read this to you. It says, or it reads, Jake, I provided Todd with a stack of reports yesterday and told him to begin reviewing them. I provided him with questions regarding the reports. He told me that he doesn't want to read them because his anxiety goes through the ceiling when he reads things and he can't function. He thought he was going to be bailed out soon. He told me that guys who have work release are coming back into the jail with drugs, and he can't stand being jailed with them, and he's about at his breaking point. I'm telling you the foregoing so you know. Todd also brought up that he thinks we should have the medical examiner's report reviewed by our own expert to rule out that it wasn't an accident, that there has to be an explanation of Amy's wounds not consistent with murder. Your thoughts? Todd also instructed me to explore whether a different company will post cash. Bob. I mean, he is expressing that we should have the medical examiner's report reviewed by our own expert to rule out that it wasn't an accident. I mean, and that is in May. So his trial, remember, was September.
Yes.
But at this point in time, starting with the third sentence of that message, let me know if I read this correctly, Mr. Firehelm. Quote, he told me that he doesn't want to read them because his anxiety goes through the ceiling when he reads things and he can't function. Did I read that correctly?
You did.
And again, in this message, is it fair to say that you were aware of Mr. Mullis' concerns or belief that this was possibly an accident, but that he wanted to rule it out at this point in time, right?
Yes.
And ultimately at the case, he didn't tell you not to proceed with conceding that this was a murder, right?
Objection. There's no foundation for that.
Overruled. The witness can answer if he's able.
I don't recall Todd ever ruling that out. Well, would you state your question again? I may have misstated.
Sure. So Mr. Mullis believed that this was an accident early on in the case, correct?
Correct.
And he held out to you that this was a possible accident at all times, fair?
Yep.
Sadie says, I'm looking up strange murder cases. Call me Sadie. To that, I say this. Do you want to be on some type of watch list? Because that's how you get on some type of watch list. When I was looking up augers today, there were, you know how Google will give you like other things you can search when you're like, because I was looking up images. I didn't understand what an auger was. By the way, you know those cage thingies? That's not it. That's something completely different. And then once I understood what an auger looks like, I went to try to see if there's pictures of the auger in the shed. That's a whole other rabbit hole. We'll get back to that. But bottom line is, on the images pages, there were other suggestions for searches. One of them was farming accidents. No, that is, I felt like Admiral Akbar as a trap. I did not click those. Nope, sure did not. Let me just go back a second. All right, here we go.
And he held out to you that this was a possible accident at all times, fair?
Yep.
But by the time of trial came around, Mr. Mullis himself even testified that this was a murder case, wasn't it?
I believe you did.
And so, in that point in time, prior to trial, you had prepared Mr. Mullis for taking the stand, correct?
Yes.
You intended to engage in a review of the evidence to allow him to tell his side of the story, fair?
Yes.
And at that point in time, on cross-examination, on the last day of trial, Mr. Mullis, in fact, conceded that this was a murder. Fair?
I'm going to object. I think the transcript would speak for itself, and the transcript is in the record. I believe that what counsel's referring to is cross-examination, and he's misleading or mischaracterizing the testimony of Mr. Mullis and the questions that were being asked of him regarding the evidence presented at trial and whether Mr. Mullis agreed that evidence was presented that it was a homicide versus an accident.
Well, certainly I'll have the opportunity to review the entire transcript and this section in particular. Mischaracterizing that testimony certainly isn't going to be helpful if that's what's happening. So the objection's overruled. Do you remember the question, Mr. Firehelm?
No, Your Honor.
All right. I'll have Kelly read it back since there was an objection, but you'll need a microphone, Kelly, if you want to use mine.
And at that point in time, on cross-examination on the last day of trial, Mr. Mullis in fact conceded that this was a murder. Fair?
I believe that's correct.
Your Honor, to clear up something, may I go ahead and present? Mr. Fireholm, I'd like to show you what's previously been indicated as Volume 5 of the trial transcript and what's previously been admitted into evidence as Exhibit 351, I believe. Directing your attention.
Excuse me, Mr. Duden. I just need to interrupt because I want to tell you guys that I know that Mr. Duden seems extra spicy, and his facial expressions seem like he's doing a bit more, but I want to caution you. Yes, he's spicy. That's just his tone. I actually kind of like it in some instances. Sometimes I'm like, okay, too much spice. But to be fair, I've sped the testimony up to 1.5, so it's exaggerated. It's not an accurate representation of the level of spice or how quickly he's making faces. That is all.
Attention to page 56. Beginning at line 12, the prosecutor asked Mr. Mullis, and somebody, beginning at line 12.
All right, so this says, answer, yes. Question, your wife, Amy was your wife, right? Answer, yes. Question, somebody that you swore to love and protect, right? Answer, yes. Question, and you feel, this is somebody you cared about. You have children with her, obviously, right? Answer, yes. Here's the line in question. Question, and somebody came onto your property right under your nose and killed her, right? That's what you're told. Answer, that's what I'm told. Question, and you know that's true now because you heard all the testimony in this case, right? Yes. Question, you know that somebody took that corn rake and stabbed Amy in the back 2 or 3 times. Let's see what the answer is.
The prosecutor asked Mr. Mullis, and somebody came onto your property right under your nose and killed her being Amy, right? That's what you're told? To which Mr. Mullis responded, that's what I'm told, right?
Yes.
And then the state asked Mr. Mullis, quote, and you know that's true now because you heard all the testimony in this case, right? To which Mr. Mullis said, yes. Did I read that correctly?
You did.
And the prosecutor next asked Mr. Mullis, you know that somebody took that corn rake and stabbed Amy in the back 2 or 3 times? To which Mr. Mullis said, yes. Did I read that correctly?
You did.
You now know this wasn't an accident. To which Mr. Mullis said, yes. Did I read that correctly?
Yes.
So we knew where we were at trial, as did Mr. Mullis based upon his testimony. Is that a fair understanding?
I believe it is.
And again, this is from this is from Mr. Mullis' sworn testimony while under oath, correct?
I believe it is.
Just pausing briefly. What's the 6:42? All right. I just want to go back to this exhibit really quickly because he should have been prepared for this. This is that I'm just going to be, because we're going to talk after this testimony is over. I want to show something to you about ineffective assistance of counsel appeals in Iowa. Doesn't do me any good to look it up. Just generally speaking, I need to be specific about Iowa. Although they're pretty much the same. For anybody that's watching now or anybody that's going to watch in the future on replay, I want everyone to know that I was specific in my Google search to Iowa to get a specific answer that as it pertains to Iowa. But this part right here, this line 16 is going to be problematic in an ineffective assistance of counsel appeal.
Now, speaking of preparation for testimony, you believed Tristan Mullis' testimony was essential to this case, didn't you?
I did.
Is it fair to say that you understood Tristan to be an alibi for Mr. Mullis?
I did.
But shortly before trial, there was some break in Tristan Mullis' statements regarding how long Mr. Mullis was out of his sight, right?
That's correct.
So Clicker AK says, sure, that's what he thought at trial because they did nothing to refute the prosecution's case or the state's evidence, which but his contention is that he never thought that it was murder. That's what this is about. What this ineffective assistance of counsel appeal is based on is that he never moved that off of what happened to Amy from day one. That he always said he always believed that this was an accident. And what happened in that question and answer portion is the state got him to agree to their theory of the case. This didn't come from his defense attorney. This came from the state. And that he should have been better prepared to testify. That's going to be problematic. I'll explain why after this. I just want us to get through this testimony. It's almost over.
Tell me a little bit about that. What was the concern?
We deposed Tristan at Al Parrish's law office. I believe Todd, I don't know if it was video or just audio, but he was listening in. And Tristan gave his testimony as to being in the barn with his mother and father, or his mother leaving, and him staying there, helping his dad, helping Todd clean things up and make repairs and such. He testified that he went into the kind of a work area at the front of the building.
This is a really good question, but not one that I am sure I understand. So Kwai asks, generally, were you allowed to change your mind in an appeals case? I feel like his evidence proves this theory. I need you to be more specific. Is who allowed to change their mind in an appeals case? Because, I mean, if you're asking if I'm allowed to change my mind any damn time I want to. The whole the whole reason behind an appeals case is what you're trying to do is convince the judge to change their mind, that the conviction should be vacated, that in this situation that it's an ineffective assistance of counsel, and that so they are trying to change. Is Todd allowed to change his mind? Todd is allowed to change his mind anytime he wants to. Okay, where it becomes problematic is if he testifies to changing his mind, right? So the basis for this, and part of the basis for the ineffective assistance of counsel appeal, one of the arguments is that Todd never believed that this was a homicide. He always believed and purported to his defense at the trial, to his defense counsel, that this was an accident. This was not murder. And at the beginning of Todd's original trial, the gentleman you see here on the screen, in his opening statements, conceded that this was a murder, but it was not committed by Todd. Then, on cross-examination by the state, Todd said he knows now that this was not an accident, this is murder. So when it comes to, he can change his mind, certainly, but you wouldn't want this is potentially problematic for his appeals attorneys. You don't really want your client to testify to a change of mind during their original trial, right? If you're going for an ineffective assistance of counsel appeal. that can be potentially problematic. And Kwai says, because I do know from personal experience, your attorneys sometimes can really push a theory on you that they think is going to win you the case, but then it doesn't, and here we are. Well, an attorney's job is to take an overall view of the evidence that's, hey, I'm Kay, good to see you, that's presented through discovery. They're intended to assess that based on their assessment of the discovery, formulate some type of plan. And one of the plans that they were talking about, which they ruled to be not viable, is the accident. Is that this was an accident, number one. Number two, that and then they went with, sorry, let me stop there, that this was an accident. Then they were going to go with the plan that they were going to go at the way that this case was investigated in the first place, that the end results are poor because there wasn't things were missed and not collected. For example, there's blood on the handle of the rake, and that was never tested. That's a problem. And they were going to try to use that to poke holes in the credibility of the investigation, the integrity of the investigation by law enforcement. And then they were going to use the alternate suspect defense, and they were going to point the finger solely at Jerry Frazier, who was currently having an affair. Yet they never brought up during the original trial another alternate suspect, which would have been a police officer, right? But the police officer had an alibi. So did Jerry. This is why the alternate suspect using those two people as a suspect didn't work. But ultimately, where we're at now in the process is this testimony from the original trial is potentially problematic for being successful in getting an effective assistance of counsel appeal. So let's keep going.
I believe to get a drink of water, and then went back in the building, the main part where the hogs would be, where he saw his dad again. And he gave an estimate of how long he would have not been able to see his dad. And it was quite short. I can't remember, 30 seconds or something, long enough to get a drink of water.
Now, is it fair to say your understanding was that Tristan's testimony stated that Mr. Mullis could not have murdered Amy Mullis because he wasn't out of Tristan Mullis' sight long enough to be able to commit the crime?
That's basically it, yes.
During the course of your investigation and prior to trial, however, Tristan Mullis' testimony changed, didn't it?
Yes.
In fact, at his deposition, where he was represented by his own counsel, Tristan Mullis' testimony, for the first time while he was under oath, changed to say he couldn't recall a specific amount of time, right?
I believe so.
And that's ultimately the same sort of statement that he made at trial, if you remember, right?
I think so, yes.
Where he was also under oath, fair?
Yes.
Was this shocking to you when this occurred?
Yes. In some ways.
Because I believe, as you stated earlier, Tristan's testimony was critical in this case, yes?
Yes.
But you worked hard in order to try and convey that Tristan Mullis was still with his dad for the bulk of the time in that hog barn on the day Amy Mullis was murdered, right?
Yes, that was critical.
You asked him questions specifically about possibly the number of times that he would have gotten a drink of water or been out of the sight of his dad, right?
Yes.
You asked him about family dynamics between Mr. Mullis and Amy Mullis, didn't you?
I think so, yes.
And I believe you, correct me if I'm wrong, but was the goal to convey that Mr. Mullis and Amy Mullis were in a loving marriage and that they were a happy family?
Yes.
And you made that effort to convey this central theme with each of the state's witnesses who would potentially say something different, right?
I think so, yes.
And if you recall, during some of the witness testimony, you asked about showing they worked on their marriage through marriage counseling, for instance, right?
Yes.
That they took trips together to places like potentially the water park, fair?
Yes.
And that they were working on their marriage and being supportive. True?
True.
And I believe during your cross-examination, perhaps of Ms. Stainer, you mentioned the messages that specifically related to Amy Mullis calling Todd Mullis super dad, or something to that extent, right?
Correct.
So at all times, you were working to convey not only a happy family approach, but also an approach that Mr. Mullis was a loving husband and father, right?
Yes.
And at least by the end of trial, you had even worked on reviewing those messages to keep instances of potential violence or prejudicial acts, like was present potentially in Ms. Stainer's messages, for instance, out of the jury's view. True?
Yes.
And that's because you not only believed your client was innocent, but you were working to convey, a solid narrative of a united family. Is that fair?
Fair. Yes.
Looking to the trial, when Mr. Mullis took the stand, do you recall asking him about the hunter safety course that his daughter was a part of?
I think we did. Yes.
And directing your attention to what I believe is trial transcript volume 4, which has been previously admitted as exhibit 350 in this case. In directing your attention to what is page 170. In scrolling down to the second half of the page, I believe, one moment. Looking at line 10 to line 14, you asked Mr. Mullis specifically if he had Googled about cheating wives or cheating spouses, didn't you?
I did.
And he denied it on the stand, didn't he?
Yes, he did.
And similarly, going down to the next two lines, Mr. Mullis denied knowing who would have looked that up, didn't he?
He did.
Looking down to the second half, beginning, I believe, at line 22 to 24, you also asked him about potential TV shows or channels that they would have watched as a family, right?
I did.
And potentially, you also asked him, going on from line 25 to the next page, about whether or not those searches could be follow-up searches on those shows, right?
That's correct.
Similarly, you evaluated or considered how they enjoyed history and of the Native Americans or Indian populations, right?
Yes.
And that there was evidence that they would watch not only shows about this, but potentially searches would align with these topics. Fair?
Fair.
Now, scrolling to what is page 174, beginning at line 14, you also asked Mr. Mullis to explain potentially some of the searches that related to starving to death, drowning, floating, those kinds of things, right?
I did.
And you allowed, or Mr. Mullis had the opportunity to say under oath that those topics were more normal or, when considered in context, were not indicative that he committed a murder, right?
That's correct.
You also, looking to line 22 of page 174 of the transcript, you asked about chest wounds, gaping chest wounds, surviving the cold, and other survival tactics or habits, didn't you?
I did.
To which Mr. Mullis answered, as we see mostly on page 175, that she was engaging in a hunter education program, an online thing, and that she was studying for it, and him and Amy Mullis were helping her review those educational course materials, right?
Yes.
And by her, I mean your daughter specifically, in this case, I'm sorry, Mr. Mullis' daughter specifically. We're late in the day, obviously.
Correct.
So you also asked about the hunter safety course materials specifically that have been, relevant not to, just to this proceeding, but what was the underlying Google searches too, right?
Yes.
In fact, when you crossed Deputy Himaseth, I believe, then Deputy Himaseth, on the Google searches specifically, you asked him to review things from K Jewelers and other things like Pinterest, for instance, too, didn't you?
I did.
And in your closing arguments, you mentioned specifically that these things suggested the iPad in question or the Google account itself were not just used by Mr. Mullis. Is that fair?
Yes, it is.
So you sought...
Just as a side note, a brief sidebar, if you will, because I have to pause for fair use commentary and all. I wonder when trials get streamed and if any of the participants at either the defense table or the prosecution table ever go back and look at the live stream and think, oof, I thought that looked good. It doesn't. And then change. I'm curious about that. I feel like if it were me personally, and I would definitely go and look, and based upon a review, I would probably change some things that I thought, oh gosh, I thought I looked fantastic in that outfit. Turns out I don't. And I would probably never wear that outfit again or that hairstyle, whatever. Just curious about that. These are the things that go on inside my brain. You're welcome. back to the testimony.
Is it fair to say, to categorize your work in this case, that you attempted at every turn to mitigate the Google searches and the state's narrative of what they represented?
That's correct.
Taking you back again to a pretrial evaluation and how it impacted your trial tactics. You were asked on direct examination about whether or not you were looking for witnesses to testify to Mr. Mullis's good character. Do you recall that?
Yes.
But you were actively in contact with his family, weren't you?
Yes.
And individuals like Tom Krogman, for instance, who were mentioned, were also interviewed by DCI as well, weren't they?
Yes, they were.
And in those reports that you received and provided, in fact, to Mr. Mullis, you would have considered his role in the case. Is that fair?
Yes.
And that would be both as a potential person to help you investigate the case and as a potential person to testify on Mr. Mullis's behalf, right?
Yes.
But ultimately, as a matter of trial strategy, you chose not to call Mr. Krogman. Fair?
That's correct.
For that question, I think it's improper to ask if it's a matter of strategy when the witness hasn't testified that there was strategy in not calling Mr. Krogman.
Overruled. The answer will remain in the record.
So, knowing how things impacted the case as it proceeded to trial 2, you were asked several questions about the 911 call. Do you recall that?
Yes.
Now, in all cases, you actually listened to the 911 call before trial, didn't you?
I did.
And it was a part of your overall investigation and discovery into this case. Fair?
Yes.
Did you also speak with Mr. Mullis about the 911 call and what happened prior to Amy Mullis, leading up to Amy Mullis's death?
I'm sure we discussed it, yes.
And to your understanding, is it fair to say Mr. Mullis conveyed to you that he didn't see how Amy Mullis died?
He said he didn't see how she was injured.
But he did tell you that he had pulled the corn rake out of Amy Mullis's back in order to be able to transport her to the hospital.
Can we get objection to foundation? When did Mr. Mullis say that to Mr. Firehome? What's the underlying context?
Mr. Duden, would you like to place additional foundation?
Sure. Early in the case, did you ask Mr. Mullis what happened leading up to Amy Mullis's death?
Absolutely.
Would that be prior to you determining what course of action or case theory you wanted to proceed with to trial?
Yes.
Would that be early on, say even before the trial information likely was filed in this case?
Probably so, yes.
So it was an early, is it fair to say that it was an early topic of discussion between you and Mr. Mullis?
Yes.
Having listened to the 911 call, that call ultimately came into evidence, correct?
It did.
And prior to Mr. Mullis's cross-examination, you had no reason to believe that the state would argue that the muttered statements under his breath that were claimed to be there were present, did you?
Had no idea.
So Kami Sadie says, I'm having a hard time getting a feel for if the judge is leaning towards one side or the other. I am too, and I actually think that's good. Because we shouldn't have a sense which way she's leaning. She should not have, she should remain completely open and objective, unlike you, Dr. Cruz, the entire time until she gets until all of the evidence is submitted. She's heard all of the testimony, and then she bases her judgment on that. You know, that's how it's supposed to go. So that's actually a good thing.
But in response to those statements being alleged by the state, in your closing argument, you attempted to undermine the value or the claim that the statements about Amy Mullis being a cheating whore or telling her to, quote, die cheating whore was on the record. Is that fair?
Yes.
Oh, I believe it was, quote, go to hell cheating whore. I apologize for that statement. In those statements, you believed that there was heavy breathing, yes?
Yes.
In that you believed he was working to revive his wife. Is that a fair assessment?
Yes.
Your arguments at each time said that the state's asserted claims were false. Is that right?
That's correct.
Now, primarily as it relates to the heavy breathing, you were shown a potential transcript of a 911 call. Do you recall that?
Yes.
And in that transcript, when you read, do you recall reading from it?
When it was shown to me yesterday, yes.
And if you remember, in that transcript, they indicate there's things like heavy breathing, right?
It did.
So, in fact, your claims or your arguments presented at closing were fairly consistent. Is that right?
I believe they were.
But is it your opinion that that ultimately came down to a weight or credibility determination for the jury?
I believe so.
And ultimately, after the trial came back and the jury found Mr. Mullis guilty of murdering Amy Mullis, you moved for a new trial and judgment, or to arrest judgment. Do you remember that?
Yes.
And you alleged that it was misconduct, in fact, to claim that those statements were made on the 911 call. Fair?
I believe it did, yes.
And so you sought to preserve that claim and also to ensure that Mr. Mullis had the fairest trial he could have, in your opinion, right?
Correct.
Oh, back the milk truck up. I was under the impression that he didn't do that. This changes things.
Now, in your more than 40 years of experience as a criminal defense attorney mostly, have you had transcripts of 911 calls be completed?
Certainly.
Have you done that yourself?
Yes.
Did you believe it to be necessary in this case?
No.
And to be fair, your arguments were to what was being said under someone's breath rather than overtly in the statements heard on the call. Is that a fair assessment?
Yes. It's my understanding that, and this was told to me by the prosecutor, that this muttering under and saying those terms was called in by someone watching on court TV, and that's how it came about.
Oh, another time court TV gets blamed. MK, have a great rest of your day, and I'll see you later. But this changes things for me slightly with respect to what happened during the original trial with this 911 call.
So you weren't really assigning a lot of weight to these claims, is that fair?
That's very fair.
Did you ultimately review the Court of Appeals decision in this case?
I did.
And to your knowledge, did that opinion or ruling speak to the potential substance of the 911 call?
I think there was a footnote to that about that, yes.
And if you recall, or correct me if I'm wrong, do you believe that that went, like you believed as well, to weight rather than a matter of fact, for instance?
Yes, I agree with that.
And that ultimately is how you proceeded in this case, right? You argued it in closing rather than sought to omit it from its admissible use.
Yes, that's correct.
And you attacked its use even after the trial.
Yes.
I've done changed again. Okay. I misunderstood the question and answer respective to that 911 call about when the issue was raised. I disagree. I think that he should have made it an issue at the time of the trial, not after the fact. I've changed my mind, as is my prerogative. Here we go.
Correct me if I'm wrong, too. At the time that then Deputy Himiseth took the stand at trial, you even asked him about UTC time, too, didn't you?
I did.
And in that line of questioning, you talked about cell phone extractions and the specific information at hand to the electronic devices like the iPad, right?
Correct.
And your course of action, is it fair to say that it was a strategic decision to proceed with attacking his credibility when you, so that you could argue what he said didn't make sense?
Exactly.
And that is what you actually did in closing, too, right?
Yes.
Mr. Fireholm, you've reviewed digital forensics information before, right?
I have.
You reviewed electronic discovery before, too, right?
Yes.
And that would include even evidence from a Cellbrite phone dump. Yes?
Many times.
So you knew how to look at the records and electronic information provided to you as a part of the investigative file from the state shared during discovery, right?
I believe so.
And you talked through that discovery and those investigative files with Mr. Mullis, didn't you?
Objection.
We did.
I don't think there's been any foundation that a conversation was ever held with Mr. Mullis regarding whatever piece of electronic evidence the state is trying to ask about.
Well, certainly there was testimony that counsel reviewed discovery materials with Mr. Mullis. Objection.
Did he answer? During those periods of time, do you recall Mr. Mullis ever mentioning planting being an evaluation during, as to why he wouldn't have been able to make those searches?
That he was planting crops?
Yes.
Is that what you mean? Yeah, he talked about his schedule of long hours and working into the night.
But he never proffered it as a reason for why he didn't use the iPad, right?
Right.
And you didn't view it from the claim that that would have made it so he couldn't access the internet, true?
Correct. Right.
And in fact, when you asked him about it at trial, when he was on the stand, planting was not a reason that was provided as to why he couldn't have made those searches, right?
I think that's correct.
But still, he denied that he even conducted those searches, fair?
Yes.
So at no point in time did Mr. Mullis, to the best of your recollection, did Mr. Mullis or his family ever provide that as a proffered reason why he could not have done the Google searches? Fair?
I think that's fair, yes.
Looking to what's previously been admitted as Exhibit 233, which I know has been the subject of communication previously. Hold, please, I apologize. One moment while we get that pulled up for you, Mr. Firehome. Do you see Exhibit 233 on the screen, Mr. Firehome?
I do.
Now, going to that last paragraph, I believe you had testified on direct examination that Mr. Mullis's inquiry about a possible paragraph, I believe you had testified.
Hold on. I just want to say this is really, really hard for me to read. Hold on. Let me make some adjustments really quick and see if I can. Hold on. All right, here goes. Push an issue that I never knew of Jerry's affair and how stuff made it look like we did, or at least I did. Taped interview of mom and dad, Tristan, knowledge, BS, argument. Something obsession with murder. I have no idea. Her history of manipulating everyone, multiple personalities, her parents and selection of friends, different situations, her dizzy spells and meds, my trying to help this story of her problems or history, plus history of her problems, how it, something with kids, her high expectations, it's too small, Tristan and my relationship, his and Randy's, Randy, Terry, Jeff, PK, the farm history of work over the years, her role, my family and relation with kids, us, other parents. Looks like vacations, clothes, my paying her debts, my role as bookkeeper, her idea, the folks. I don't know what that says. Maybe he'll read it and we'll have a better time. I should have just stopped. I should just let him read it. Here we go.
On direct examination, that Mr. Mullis's inquiry about a possible quote unquote expert, you believed it to be just shotgunning. Am I right?
Yes.
And if I understood your testimony correctly, and please correct me if I'm wrong, this was because you and Mr. Mullis had evaluated different kinds of defenses and different ways to proceed at trial well before the trial ever took place, true?
That's true.
And this included what witnesses to call, including any potential need for an expert witness, possibly.
Yes, that's correct.
But looking at this page, if you don't mind scrolling to the top, thank you. On 233, do you see where it begins at number 18?
Yes.
So in this line, is it fair to say that this looks to be an incomplete list?
Yes.
And this exhibit actually doesn't have a date on this note specifically, does it?
I don't see one.
Do you even know when this note would have been sent to you?
I would have no idea.
How, other than the notation of legal up top, would you know that this was meant for you?
That would be my guess, that if he wrote legal on there, that the jail would let him mail it or something. I don't know.
Well, knowing that, Mr. Firehelm, I'd like to scroll and draw your attention to what I believe is page 2 of this exhibit. Does this page have a date either?
I don't see one.
So like before, you don't know when you would have received it, if at all. Is that fair?
That's correct.
And you don't know when it would have been sent or what it would have been about. Is that fair too?
That's fair.
Now, if you want to go ahead and review a little bit of this text, Mr. Firehelm, specifically the first 3 sentences, I'd like to ask you about the context of what this letter shows for you.
All right. So this I can read. And this shit Travis said about all computer stuff being male related. She looked up more porn and stuff than I did. I guess it boils down to Tristan and his testimony. He is so criticized. He is absolutely critical in this. I think the Angie in the text, Terry, could possibly be a gal Terry works with at Saint something. When Bob said lawsuit, I think this Angie was married 40-plus-year-old who had relations with a 17-year-old boy and would get fired or something. It's possibly this gal, but I don't know for sure. Let me make sure everything's okay over here. Yeah, it is. Okay. But I don't know for sure. Either way, if Amy said some shit to Angie, I didn't know. This BS about me putting Taylor in snow and other crap is such bullshit. It just irritates me. The Dr. Thompson stuff, I'll leave to the lawyers. Hemaseth or whatever acted like he didn't know what the augers were. Dr. Thompson didn't say much about anything except the bruise on Amy's chin. He said the knee scrape and hand scrapes could be from chores that morning. My mind goes all over thinking of this, that the scrape on chin was unpaved or some shit, I don't know. The concrete where she was laying was edge of concrete like this. Her head was here when found her. I've speculated so much on this, it's getting old. Sounds like no one actually looked at clothing, took pictures is all. Really, what do we have to do? Do we need more than Tristan or not? Seems like the state can get her family for witnesses. I guess I got Tristan, but he is with crooked people. But that shouldn't get him to say anything but truth. All right, there we go. That's the best I could do, you guys.
Okay.
Now, when you're going through this message, do you note that there's various individuals and different witnesses that the state called at trial?
Yes.
In conversations about the inclusion of, say, porn or the testimony of someone being critical, this case being Tristan, was important for not only trial purposes, but also for your case, right?
Yes.
Is it fair to say that you cannot with certainty say that this case or this letter was not received or, an insight after trial, for instance?
It could have been. I mean, I can't tell. I'm just looking at it.
In fair point. So there's no way to know when this would have even been sent to you, if it was sent to you at all, right?
That's correct.
All right. To be fair, the state is correct in this. Jail mail is notoriously slow and delayed. Both ways, delivering it and mailing it out, because there's things that have to be done, especially mail coming in the jail. So it is, because there's no date on this, it is conceivable and possible that while this was written prior to trial, the trial itself was not that long. There were 3 whole days, maybe 4, of actual trial. It's possible that that it was mailed, that it was something that he sent prior to trial, but then it didn't get received until after trial. Erica says, farm work is tough, and until someone works on one, it's hard for people to understand the dangers. I would have bruises and cuts and not know how I got them. Yeah, I mean, I totally get that. And I think just anytime you're doing anything physical in general, like when I was packing the house to move from Florida to Texas, when I got to Texas, I was all like I had cuts, I had various bruises, and if somebody would have asked me how I got them, like to be specific, I wouldn't have been able to be specific. I was moving stuff. I don't know when these bumps and bruises occurred, just over the course of moving. It could have been while I was loading the moving van in Florida, and it could have very well happened when I was unloading the moving van when I got to Texas. I mean, at the end of the day, stuff like that. When you do physical work, you come home with bumps and bruises, cuts and scrapes, and no real memory. I mean, unless it's something traumatic where it's like a super deep cut, or you get a knot on your head or something like that, you don't typically remember exactly what you were doing at the time. That's typical.
Now moving to the next page of the same exhibit, what is page 3, I believe. Focus on the screen. The first word on that screen, if I'm reading it correctly, is Lynn, correct?
Yes.
Now, I don't mean to, play games here, Mr. Firehelm, but is your name Lynn in any case?
No.
Is this any indication that this letter was even sent to you?
Doesn't look like it was.
So it's fair to say that it was actually not even a letter to you at all about the case, right?
That's quite possible.
And going to the next page, page 4, and I don't mean to beat a dead horse with this or anything, but this one's also addressed to Lynn, right?
It is.
So much of this document, if we'd like to proceed to the next page, for instance, or some of the others, would suggest that, again, I believe Lynn is the name shown in the top corner with a date, actually, on this copy, right?
Yes.
And that date is August 29th of 2019, right?
Yes.
So this letter, too, was not addressed to you, right?
It appears not, yes.
So looking back on it, these ideas and insights from Mr. Mullis were not likely provided to you. Is that a fair assessment?
I don't remember seeing these, no.
So much of these ideas are either unbound in time or you're not the addressed recipient or intended recipient of this. Is that fair?
It's fair.
But drawing your attention to the other evidence in this case, and I don't need this specifically anymore, you discussed the DVR cameras or the security cameras on the Mullis farm too, didn't you?
Yes.
And that was on direct examination. You discussed how potentially those cameras would have gone out, right?
Yes.
Question of foundation, direct examination of who?
Your direct examination,
Of Mr. Mullis?
Mr. Fire.
Oh, sorry. I was, okay.
She
And
did
just
ask
for clarity of
about
the
that.
record, during the direct examination of you, Mr. Firehelm, shortly before, you discussed those DVR security camera recordings, right?
Yes.
But that direct examination wasn't the first time you actually discussed those cameras, right?
Correct.
At trial, do you recall that you alleged, like Mr. Mullis had told you previously, that potentially the cat had knocked it off or interrupted the signal? Is that fair?
Todd told me that, and so did his brother Mike, and maybe even Lynn, too. I don't know.
So you investigated that evidence, didn't you?
Yes.
And you took not only Mr. Mullis at his word, but the support system that he had in place of his family too, right?
Yes, and I went and looked at it, and, maybe I shouldn't volunteer. I'm sorry.
Well, I'll go ahead and ask the next question. What is your insight on this issue specifically? What were you just going to say?
I grew up on a farm with dairy cattle and cats and corn rakes and so forth. I was proud of myself as an attorney when I walked into the courtroom and talked to jurors and argued cases to have that practical experience. And when I walked into the shed and looked at the window and how it was situated, cats like to lay in the sun. I think that window faced west in the winter part of the year. All these things make sense. So that's what I meant. I'm sorry.
And again, you believed in your client's innocence through the trial, didn't you?
Very much so.
And you argued till the end of your representation that Mr. Mullis was not the one who had murdered Amy Mullis, right?
I did. That's correct.
But you knew what evidence would be essential to your case, didn't you?
I did.
And that critical piece of evidence was going to be Tristan Mullis' ability to provide an alibi for Todd Mullis at the time, correct?
Yes.
So when he changed his story specifically, or when he was potentially not going to be available to testify, you brought that to the judge's attention, didn't you?
I did.
Drawing your attention to what's previously been marked and admitted as State's Exhibit I. Let me know when you have it in front of you, Mr. Firehelm.
I have it right here on my desk.
For clarity of the record, Judge Bitter was the judge who presided over the case at the criminal trial level, is that right?
That's correct.
And so this email is dated August 13th of 2019, correct?
Yes.
And so this lengthy email with representatives of the state as well as for Tristan Mullis and your team too were included on this message, correct?
Yes.
Just in case he doesn't read it. It says, Judge Bitter, well, it doesn't say, it's a letter. It reads, Judge Bitter, this email is to give you a heads up on developments in this case, which is currently set for trial September 16th. I know that Al Parrish has informed you that he has been retained to represent Tristan Mullis, our client's 14-year-old son. Tristan is not listed as a witness by the state in the trial information, but the defense is planning to call him as a witness. Tristan and his siblings are residing with the maternal grandmother and her husband, Ankeny. The children have been placed there pursuant to a guardianship order from Polk County. Mr. Parrish informed Maureen and I in a phone conference yesterday that he had spoken to a counselor who has been seeing Tristan on a regular basis. Al indicated that she has had 12 sessions so far with him. Al also shared that this counselor recommended that Tristan not be called as a witness in either a trial or depositions, at least not at this time. In a phone conference that I had this morning with our client, I informed him of these developments and asked him his position on whether or not he would agree to delay the trial to allow Tristan more time with this counselor with the goal that he reached a point where he could testify, mainly because of the uncertainty of how long this process could take and that he is incarcerated awaiting trial. He was opposed to continuing the trial date. In a phone conference that I had with Al this morning, I shared our client's position with him. Al indicated he would try to have something on file with the court asking for a protective order by the end of the week. He had asked Maureen and I yesterday if we would agree to have the counselor testify by phone in any hearing that might be necessary, which we agreed was okay.
And in this message specifically, you inquired about whether or not waiting for Tristan's potential issues addressed with his counselor to be addressed sufficiently so that he could testify at trial, right?
Yes.
Yes, he has represented that he is a cat expert. Alice objected. Anybody that's an actual cat expert would never use those words because, as we all know, dogs have owners, cats have staff. That's her words, not mine. Alice was unimpressed.
And in order to ensure that he testified at trial, you floated the idea of a continuance to Mr. Mullis, didn't you?
I did, sorry.
And in speaking with him about this, Mr. Mullis was adamant that trial should proceed as scheduled, wasn't he?
Very much so.
And so he was opposed to continuing the trial date, and that was your position too, wasn't it?
He was opposed to it.
And at this time, trial was set for September, right?
Yes.
So in the interim between this email and when you began trial, you deposed Tristan Mullis, didn't you?
Yes.
And that was when his story changed, yes?
Yes.
But you proceeded to trial in September because Mr. Mullis did not wish to ask for a continuance, right?
That is correct.
So when we look at that September timeline, you were also asked potentially about whether or not he would have a fair jury that, at least my understanding would include potential farmers as well, correct?
That's how I understood it, yes.
But it was Mr. Mullis who wished for the case to proceed that month, right?
Yes.
In that month, I mean harvest season, true?
Yes.
And you were following the directions of your client, is that fair?
Yes.
So you proceeded to trial, but you had previously moved for a change of venue, right?
Yes.
Now, with about 40 years or more now of legal experience, is it fair to say that you know a judge would decide what venue to send it to rather than the parties specifically shopping for one?
Objection to the characterization of shopping in the state's question. It's inflammatory and prejudicial.
Would you like to revise your question, Mr. Duden?
Sure. Mr. Fireholm, in your experience as a lawyer.
This is a really good point. So Charlie says, I only ask if you still have your hubby and dog because you said I was able to instead of we. And I did. That is what I wrote. I am frequently, usually when I talk about things, I refer to myself. I try to keep my husband as much as I can, because the rules of engagement are different and vary from person to person, but I usually try to keep him out of it. But yes, I'm sorry. The we is, it was we, my husband and I moved back to Texas. Yes. Yeah, I do. I miss Nestor a lot. But I know that the universe knows much more and knows better than I do. And the truth of the matter is, to make that drive from Florida to Texas, it took us 24 hours. It would have been incredibly hard on Nestor at his age, first and foremost. And second of all, Texas has an actual winter, particularly the part of Texas that I'm in. I'm in far north Texas now. And they have an actual winter, unlike Florida. And because he was 15 when he passed away, it would have been really, winter would have been really, really hard on him. He was starting to get, arthritis and stuff. So the universe knew best. And they decided that it was time for Nestor to cross the Rainbow Bridge. And that's where he is. All right. I was just a quick sidebar. Sorry about those on replay. Let me rewind really quick.
Would you like to revise your question, Mr. Duden?
Sure. Mr. Fireholm, in your experience as a lawyer with more than 40 years of practice under your belt, do attorneys get to choose what forum they go to when they move for a change of venue?
They don't have the final say, no.
Is it fair to say that a judge would make that ultimate decision?
Correct.
And in this case, a judge decided to move the venue to Dubuque County, right?
Yes.
And at that time, the concerns were ultimately revolved around whether or not Delaware County and Dubuque County were in the same media market, true?
That was one of the concerns, yes.
But you had asked prospective jurors when selecting a jury about potential exposure to media and their biases, didn't you?
I did.
So you sought to address those concerns to ensure your client would get a fair jury or a fair shake, right?
Yes.
And ultimately, when the jury was selected, did you have concerns about there being a fair cross-section or whether or not more representation of farmers or anything like that were going to be dispositive in this case?
No, I thought that this panel during voir dire was one of the more cooperative ones that I had encountered in trials, and I felt the cross-section was pretty good, actually.
So, in your opinion, the selection of the jury was fairly good for the case that was at hand?
I did, yes.
To be fair, you never know what a jury is going to do because, once again, jurors are comprised of people and people are going to people. You can think that you have impaneled the most open set of human beings that are receptive to what you ask them to do, which is to only and solely base their verdict on the testimony and evidence presented in court. And if they say they can do it, you have to take them at their word. And in this case, I think, quite frankly, that the jury felt like they did exactly that. I think that they listened very intently. I think they paid attention. I think that they did base their verdict solely on what was presented in court. And perhaps if more of a defense had been presented in court, perhaps the verdict would have been different.
And to your knowledge, at any point in time, was it conveyed to you that there was a concern about a lack of a fair jury or cross-section being selected?
I don't recall. Once we got going and the jury was picked, no, I don't recall any concerns by Bob, me, or Todd.
So is it fair to say that it wasn't really a concern for you in the Mullis defense team?
I think that would be fair, yes.
You had spoken at length about Jerry Frazier while on direct examination in this case, correct?
I think so, yep.
And specifically, at trial, were you pointing to Mr. Frazier as a potential person who would have motive to kill Amy Mullis as an option?
Yes.
You weren't necessarily saying that he was the murderer, were you?
No.
you were in fact pointing to many other people who could potentially have reason to commit the act, right?
Yes,
And again, at all times, you were maintaining the narrative that Mr. Mullis did not commit the act in question, yes?
correct.
That he didn't murder his wife.
That's right.
Now, my understanding, Mr. Fireholm, based upon your prior deposition testimony, is it fair to say you view the role of a defense attorney as one to sow doubt or reasonable doubt into a case rather than to prove the alternate versions of a crime, right?
Exactly.
That the burden is the state's to prove that a crime was committed, in this case a murder, not your burden to disprove it.
That's correct.
I mean, he's not wrong. That's really the truth. Also, you're welcome. I forgot to say, hey, you're welcome to you, Charlie. So Charlie says we would still be sitting there for the first trial if I were on the jury. Too many questions still. For me, I would have voted not guilty. Here's why. Not because okay, let me start again. Here's why I would have voted not guilty. There's a big difference between not guilty and actual innocence. And what I'm saying is I would have voted not guilty. I would have voted not guilty because I do believe that there was reasonable doubt, and it wasn't it's relative to the injuries that Amy sustained. I never understood clearly or agreed with the state's theory of how and in what order those injuries occurred. And I was left with doubt that it could only have happened as a result of another person inflicting those injuries using the corn rake on Amy. That was enough that would have been my reasonable doubt, and that's why I would have voted not guilty. It's a much different burden for me, frankly, to get to an actual innocence, but I would have voted not guilty for sure. There was reason for me, the injuries, and I got to say, to be very, very clear, my verdict of not guilty, should I have been on this jury, would have been based on absolutely nothing that the defense presented. That's all.
And so, in this case specifically, you were looking to provide potential other avenues that would sow that doubt in this case or help you secure a not guilty verdict for Mr. Mullis, right?
That's correct.
Mr. Fireholm, in your experience, would you say that you provided zealous advocacy for Mr. Mullis in this case?
Objection to the vagueness of zealous advocacy, and it's inappropriate to ask Mr. Firehelm to judge his own performance.
Overruled.
Once again, I pride myself that, especially with the jury trials, that these situations for my clients are extremely stressful, important to them. In Todd's case, the most stressful, facing a life sentence. And I don't take that lightly. And I believe I did everything within the time frame that we had. That I did everything I could to obtain that verdict of acquittal.
I guess it's one of the last things that we need to talk about. Did you advise Mr. Mullis on his rights as it related to his ability to testify or not?
Yes.
Before trial, before he took the stand, did you work to talk through his testimony and help prepare?
Yes.
And in your professional opinion, or do you recall any instance specifically to which Mr. Mullis would have expressed concern or doubts about any of the process for him to take the stand?
I don't recall specifically. I mean, clients frequently say, I don't want to blow it. I'm nervous, those kinds of things. But I don't think Todd, it wasn't like we had to drag him to the stand. And frankly, I thought he did a wonderful job.
Were you watching the same trial I was watching? I thought that Todd's testimony started out good. It's always better on direct, obviously, because, but but I don't know that he was, I don't know that I feel like he was adequately prepared for cross-examination. I'm not sure.
So just to confirm, you didn't encourage Todd Mullis to plead guilty.
Correct.
You didn't advise him that he should waive a jury trial.
No.
You didn't tell him not to testify on his own behalf or that he should, one way or the other, really, did you?
No.
You didn't force him to take the stand, right?
No.
And you never encouraged him to forego an appeal, did you?
No.
Hold on. I need to rewind that because I want to hear this question again. And I don't have the aid of closed captioning, so sometimes I might over rewind. Just please indulge me.
So just to confirm, you didn't encourage Todd Mullis to plead guilty.
Correct.
You didn't advise him that he should waive a jury trial.
No.
You didn't tell him not to testify on his own behalf or that he should, one way or the other, really, did you?
No.
Okay. He should, in my opinion, have went through all the if, then, but clauses respective to testifying at a trial, at his own trial, not just a trial in which he's charged with the offense of murder. I do think I think he should have been advised. So Charlie asks, who decided that Todd was allowed this hearing? A lot of inmates don't make it this far. So getting this trial, doesn't it say someone believes his claims are possible? So the way that it works is the defense, they aren't really referred to as the defense in this process. They're actually called the applicant. But the applicant, his attorneys would have filed this ineffective assistance of counsel appeal, and they would have listed why they believe his trial attorney was ineffective, and then they would have submitted supporting evidence, etc., to that. So then what would have happened is a judge would have reviewed that, and it's possible that a judge said immediately based on this motion, okay, yes, we need to have a hearing about this. It's also possible, because I don't know exactly how the process went for Todd specifically. It's also possible that initially the initial appeals judge who looked at this said, no, but the appeals can be appealed. So bottom line is, at some point, a judge looked at this motion and said, I think we need to have a hearing about this. And that's why we are where we are currently.
You didn't force him to take the stand, right?
No.
And you never encouraged him to forego an appeal, did you?
No.
To that end, was the choice to plead not guilty and maintain his innocence all the way through trial, did you help Mr. Mullis maintain that objective through trial?
As best I could, yes.
In the arguments that were chosen to pursue, the argument specifically was to pursue believing that this was a murder, right?
Yes.
And as a brief recap, you reviewed the discovery yourself with Mr. Sabers and Mr. Mullis, didn't you?
A number of times.
You deposed witnesses in this case to ensure you understood the different theories of the state's case as well as possible theories for your case, right?
Correct.
You always believed that your client was innocent and held out to the jury that Mr. Mullis did not commit the murder did not murder Amy Mullis, right?
I did.
And you worked to address the pitfalls and concerns of Google searches or electronic evidence, didn't you?
I did.
And you sought to make sure he was prepared and ready to proceed in maintaining his innocence and helping prove his innocence when he took the stand, right?
Yes.
I don't have anything further. Thank you.
Can you redirect?
I do, Your Honor. Would it be possible to take a very short break just to get organized, and then I'll be ready to go?
Probably just a real short break.
Certainly.
Yeah.
Certainly.
I want to reference State's Exhibit F, the email from April. I think you have that.
Really briefly, I have to be honest and I have to be fair in my assessment of what we're watching. And I actually think that Mr. Duden did an excellent job at questioning Mr. Jake. It did cause me to rethink some things. It doesn't, but I will say this: after listening to the direct examination and the cross-examination testimony, it does not move me from my original opinion that Todd Mullis deserves a new trial. That is all. All right, here we go.
I want to reference State's Exhibit F, the email from April. I think you have that.
I do.
And in that email, it says, we need to have an expert take a look at the autopsy. Is that what it means?
That's what it says, yes.
But you never did do that.
No.
Do you recall a note that was passed to you after your opening statement that said WTF on it?
I eventually saw it. I'm not sure when.
Did you understand that to mean that your client didn't know what you were going to say in opening?
I'm not sure what was intended.
Did you talk to your client about it?
No, I don't think so.
And you would agree with me that Mr. Mullis never told you he believed it was murder?
I'm not going to say he said those words, no.
You talked on cross about it was the state's burden to prove beyond a reasonable doubt that a crime had occurred. Do you remember that?
Yes.
And would you agree that in your opening you conceded a crime occurred?
Yes.
And would you agree that Todd always maintained it was an accident?
He always maintained that that was possible, yes.
And in your deposition, you testified that Todd never agreed with you that it was murder. Do you remember that?
I think that's what I said, yes.
You testified on cross that Tristan, you considered him to be an essential witness because he was an alibi. Do you remember that?
Yes.
I just want to go back to this really quickly that Charlie said. When Charlie wrote, who decided that Todd allowed this hearing? A lot of inmates don't make it this far, so getting this trial, doesn't it say someone believes his claims are possible? I want to clarify something really quickly. I would assess it or explain it more. It's not that someone believes that his claims are possible. What I would say is that a judge looked at this and believed that some of the claims have potential merit, requiring a hearing to further explore those claims. That's how I would characterize it. And also, oh my gosh, thank you, Charlie. That was so sweet of you. Thank you very much. That was very generous. Charlie said, thank you for answering all my questions. You are so welcome. I appreciate that very, very much. I think that semantics in these situations are incredibly, incredibly important. And I want to give you guys the correct information. And so to say that somebody believes his claims are possible, the more, in my opinion anyway, the more accurate way to represent that would be that someone believed his claims have merit, requiring a deeper exploration of them, resulting in a hearing. That's how I would put it. That's how I would put it. All right, here we go.
Tristan's testimony was only essential if you believed Amy's death was the result of a homicide, right?
Yes.
You were asked about the change in Tristan's testimony in his deposition. Do you remember that?
Yes.
Did you do anything to present all of the prior statements Tristan had made before his dad was arrested that indicated he was with his dad the whole morning?
I think we did, yes.
You were asked about the Google searches and the electronic evidence. Do you recall that?
Yes.
And you've also told us that you prefer paper over electronic documents, right?
As far as maintaining the files and exhibits and discovery, yes.
And I've showed you several things today that come from electronic discovery that you didn't have before.
Yes.
I want to go briefly back to Exhibit 233 that the state showed you and asked you about as well. Do you recall testifying in your deposition that this was Todd's handwriting and a letter you received from him?
No, I don't recall those specifics, no.
Let me find the page for you here.
It's really possible that what occurred with this letter is that Todd likely wrote this letter maybe to his sister and wanted his sister to give it to his attorney based on the address or the envelope that was presented during cross. "Aw, Sadie, this is so sweet." She said, "Jen Lou, you are wonderful. I love that you give credit to those you don't agree with if they make a good argument. Finding the ward has been a real blessing to me." Well, thanks, babe. And we're blessed to have you. I try to see things from others' perspectives, even if I don't actually agree with their like in this situation. I think that the state did a great job cross-examining Mr. Jake. I have to say, I mean, did it change was it enough to change my mind? No, but they still did a good job. And at the end of the day, does it really matter if it changed my mind? No, because I'm not the fact finder in this case. Although I would like to point out, not so much in Iowa because they get real winters there, but I am excellent at sharing the screen. And I know how to work Control F like a pro. So if any attorneys out there are looking for a person to operate the share screen during trials or depositions or hearings such as this one where evidence needs to be presented, I'm yo gal. All right, here we go.
Elena, you put it in there. Okay, Mr. Firehelm, you have a copy of your deposition in front of you, right?
I do.
And for the record, it's our exhibit 323. If you could look at page 19 and start at line 22. And read through page 20, lines 8 through 13.
Read to how far?
Page 20, lines 8 through 13.
Okay, I've done.
And does that discuss letters from Todd?
Yes.
If you would go back to looking at 233, and we'll scroll to the third page. Do you see a date there at the top? I'm sorry, it's not the third page, it is the fifth page. My apologies.
Yes, I see that date, August 29th.
2019.
Yes, correct.
This would have been about a month before Mr. Mullis' trial.
About 3 weeks, yeah.
And you testified earlier that you spoke with Todd's sister Lynn a lot during your representation of Todd.
Yeah, quite a bit, yes.
And that Lynn would give you information as well.
Yeah,
And that she would call you or email you and say Todd needed to see you or talk to you.
that was common, yes.
If you go down to page 10 of 233, do you see the handwriting in the middle of the page at an angle?
Yes.
What does it say?
Lawyers first, then Lynn or Mike.
So is it entirely possible that this letter was sent to you?
Objection, speculation.
Overruled. The witness can answer if he's able.
Anything's possible, but I just don't think so.
But you were representing Mr. Mullis August 19th, 2019. So you would have been one of those lawyers referenced on page 10.
I assume so, yeah.
Do you remember signing an affidavit regarding your representation in this case?
Yeah, I remember signing one, yes.
It's Exhibit 224. We can show it to you. I don't know if you have it.
I think I have it.
Can you see the one on the screen?
Yeah, I just found it. I have it in front of me.
Okay. You were asked about the 911 call that was played for Todd on his cross-examination.
Yes.
And in this affidavit, can you read paragraph number 10?
Objection.
I did not.
That's not an evidence, Your Honor. This is not an admitted exhibit, and consistent with the court's order on day one, affidavits have not and likely would not be admitted.
Your Honor, I was asking the witness to read it to himself. I apologize. That wasn't clear.
Okay, so for now, at least, the objection will be overruled.
Let me know when you've had a chance to read paragraph 10.
I have.
And do you recall me asking you earlier about whether you asked for a move for a mistrial after that 911 call and the arguments were made by the prosecutor?
Yeah, I think you did.
And with all of the decades of experience, have you moved for a mistrial before?
Yes.
And do you agree that you could have and should have in this case?
In hindsight, I could have.
And in fact, you've said before you should have.
Right.
You were asked about conducting depositions leading up to this trial. Do you remember that on cross?
Yes.
You testified earlier that you didn't conduct any research or investigation before those depositions. Is that still true?
Research as to what?
To prepare for depositions regarding the electronic evidence or any other topic?
I reviewed the discovery that had been produced.
Other than reading police reports, you didn't do anything else. Is that correct?
Talked to Todd, talked to Bob, Lynn, Mike, those kinds of things.
And you didn't consult any experts to help you understand the evidence?
Objection.
That is
The answer within the scope of the direct and the cross, Your Honor.
Overruled. If there is an answer, it will remain in the record. Okay. I don't think there was. Mr. Firehelm, do you remember the question?
I started to say it. What my answer was, that's correct.
You were asked on cross about complying with Todd Mullis's wish to not continue his trial. Do you remember that?
Yes.
Do you disagree that you didn't comply with anything else that Todd asked you to do as far as consulting an expert regarding whether her injuries were the result of an accident?
Objection. Argumentative in the state's testimony.
Overruled.
I don't view my response to Todd's references to getting experts as ignoring him, or whether I complied with him. I think I've explained that before, how I viewed that.
You were asked several questions on cross about investigating issues. Are there actions you took that we have not discussed today?
Just really quick here, recliner detective. It's good to see you. It's been a long time no see. The recliner detective says, doing great. I too have reasonable doubt. I feel she may have passed and fell on the rake. See, that's kind of, I have some reasonable doubt there. And more to the point, I think a lot of the problem is the language that they're using and what they're saying fell on the rake. I actually think if they would have broken it down into two separate things that occurred causing one event, I think that the jury, it may have been better understood by the jury. See, I think that she tripped and was falling and ended up landing on the rake. I think that the obstacle in many people's minds is the word fell on the rake. I think if there was a good theory put forward about what caused the trip to begin with, like, and it could have been many, many things that attributed to that, to her tripping, right? There was testimony about medications that she was on, which would cause dizziness, sleepiness, and there was that space was small and full of other things in the way of Amy getting to that carrier. The carrier was up on a shelf, which would have made her reach. And so I think if it had been spoken about in that way during the trial, I think it would have been easier for the jury to understand.
The only thing I can think of is in some cases, as a member of the Iowa Association for Justice in the criminal group of that organization, we have a pretty active listserv. So once in a while, an issue will come up, and rarely will the attorneys, and I'm one of them, will we give the name of a case or a client's name or something. But if it's an evidentiary issue or something like that, I think I probably did that in this case. I don't remember specifics, but that's one thing other than what we've talked about, I guess.
Thank you.
So Neat Noodle says, that's interesting. The choice of landed on or fell on makes no difference to me. And I think that I can see why it would make no difference to you, Neat, because of your experience, right? So our experiences shape our perceptions and our perspectives. I think that because it sounds to me like the jury that was impaneled in this case wasn't comprised of a lot of farmers. I do think that perhaps it's possible that describing it in the way that I did, using the language I did, would have, I think, potentially made a difference. And Paul says, yeah, they framed it in a way that creates the visual of falling, standing up, and pulling it all out, then falling and pulling it all out again, and then falling on it a third time. Yeah, I think that I think you're right, Paul. Like, I think that it's really, really important to use the right language when you're describing something to people who were not there, and all they have is photographs of the aftermath. So Tony says, good thought, Jen Lou. I agree. She was already getting dizzy and needing to rest before the fall. Recliner detective says they should have showed her blood work. My guess she was very anemic and easily passed out due to recent uterine ablation. I think that was her recent surgery. Yes, they referred to it as a DNC, but yes, that was her recent surgery. Charlie says, was the rake hanging up or resting against the wall? Was the handle of the rake going towards her head or her butt? Okay, here's the issue. We don't actually know exactly where this rake was located. What we have is Todd's statement about where he last put that corn rake, and it was leaning up against the doors of the red shed. The problem with that is when he put the corn rake there, we don't know whether the handle was touching the ground, the tines were up, which way the tines were facing. Were they facing towards the shed doors or towards the shed? And there were several weeks in between the time that Todd put that corn rake where he put it and this incident. So because it's not a shed that was locked, other people had access to it and it could have been moved. Okay, so Neat Noodle points out that a DNC is different from a uterine ablation, just FYI. I must confess that although I am in possession of a uterus, I don't know, I'm not familiar with most of the medical procedures beyond a hysterectomy, childbirth, which is childbirth's not a medical procedure unless you have a C-section, but you take my meaning. I'm not really great at remembering all that stuff, and I should being in possession of a uterus, I should probably educate myself. Paul says, we know the rake impaled her with the handle down, so it was either on the ground or against the wall with the tines up. Important to note. I think I've been blessed in that department. Tony says, an ablation is when they scrape the uterus, it gets rid of your period. It's for folks that have really heavy periods. Yeah, see, I don't have personal experience with that. So thank you guys for educating me, because I like to know. I feel very strongly about, if you know better, you can do better. And so now that I know better, I can describe things and explain things better. So Tosh says, IDK, something in my gut leads me to believe Mrs. Mullins fell. She was overexerting herself. I think she was cramped, dizzy, and unfortunately fell in a corn rake. I think, like you said, she got up and pulled it in and out multiple times. I mean, I think that she was successful, but not successful at the same time. Like she wasn't able to actually completely remove the corn rake from her back. Only 2 of the 4 tines was she able to remove. And unfortunately, the 2 tines that stayed in were in areas where the area that they ended up injuring inside of her body likely would have made it very difficult for her to be successful in pulling it out completely. In my opinion, anyway, from the testimony.
I wanted to follow up on the testimony by Deputy Himsath at trial about the timing of those Google searches. Do you recall that?
Yeah, kind of.
Do you know why you didn't impeach him? That he had the calculations of the timing of those messages wrong?
I guess I thought we did to some extent. I don't remember exactly how the record reads.
So Patricia says, if she fell on it and it penetrated her body and she was able to get up, she may not have had to pull it out. The action of getting up may have dislodged part of it and causing her to fall again. See, I think that oh, I didn't know that, Tosh. I didn't know that kawaii just means small and cute in Japanese. I love that. Okay. See, I think that I think the action of getting up, I think, is an overstatement, right? Because in my opinion, I think what it implies is that she was able to get all the way up to a standing position. I think potentially, if we're discussing the accident theory here, I think the better way to describe that would be an attempt to get up, because I don't know that we have heard any testimony or seen any evidence that Amy was able to get up from falling to a completed standing position. right? Meaning, and I don't mean that she needed to be fully upright. I just mean that she's standing with her feet under her. Do you know what I'm saying? With her feet on the ground and under, standing like that. So, yeah, I'm curious. I wonder about that. Yes, I do wonder if she was, you know, if that's, her in her attempt to try to get up off of the rake, it dislodged two of those tines.
You understand how to do a UTC calculation?
Yeah.
So if you didn't impeach him, you don't have a reason for that?
I guess whatever I did, I did. I'll stand on the record.
You were asked on cross about the hunter safety certificates and guide and the questions you asked Todd Mullis. Do you remember that?
Yes.
Did you obtain a copy of that guide and compare it to the Google searches?
I don't believe so.
Did you talk with Todd's daughter or Tristan about what types of searches they might have done?
I don't think so.
Did you only put Todd on to explain that, to testify?
Yes.
You were asked about your email in April where you believed it was murder, based on your review.
Yes.
And you were asked about working with an accident reconstructionist or a biomechanical engineer, I think.
Yes.
Have you worked with an accident reconstructionist before?
Yes.
But you did not do that in this case.
Yes. That's correct.
Do you recall being asked in your deposition whether you had the consent of Todd Mullis to concede it was a homicide prior to making your opening statement?
I don't recall specifically, no.
If we could go to your deposition, page 22, I think, or is that 23? Oh, line 23, page 22, line 23.
Yeah, I see that.
And your answer to that question about whether Todd consented was no. Not like I'm okay with that, no.
That's what it says.
So any testimony you gave today that you think Todd knew is different than your testimony from your deposition?
Well, if that's the way you interpret it, that's not what I meant. What I testified to today, I think, is that I felt that Todd had acquiesced in that concept.
Tosh says, did I miss them going over the Google search history? I know my Google history would be jarring, but I just Google really random things. They did. That testimony would have come on day 4. So Monday, I played that. And we kind of skipped around a little bit. I mean, I played it almost all the way through, but I did skip towards the end because it just became a little bit dry and tedious, and we got the point. So they did testify about that. And basically, the expert that testified for the applicant/defense said that based on all of his findings, extractions, all the things, that Todd Mullis couldn't have been the person to do those Google searches, the really damning ones, because they correlated with a hunter's a hunting test that sort of a hunter safety test that his daughter was taking. And they also corresponded with certain shows located on the family's DVR that were watched around the same time as, that was his testimony, around the same time as those searches were done. So that is what he attributed those searches to.
Mr. Firehelm, did you understand Todd to always maintain that it was an accident that injured Amy?
I'd have to answer that yes.
Oh, hold on. This is interesting.
But yes, but.
So, Neat says, Paul, I appreciate your comment regarding the rake. As a former farm kid, it is far more likely the rake was on the ground. We would never stand one up by the handle. Okay, so I understand that. Not putting it with the handle down on the ground. But what about if you were to hang a rake up? Because I remember being a kid and I was just a city kid, and when I say a rake, I'm talking about a rake that you would use to either the plastic kind that you use to rake leaves, or the metal kind that you use to like rake dirt. When they were hung up with by their ends. The metal one was. The plastic one, if I remember correctly, was hung up. There was a hole at the top of the handle, and they fit on like pegs in the garage, and that's how they were stored in the garage. But but the metal rake was hung with the handle facing down.
Yes.
But you did not present that theory or investigate that theory for him. Is that accurate?
Didn't present it. I'm not saying we did investigate it.
But did you talk to any experts about it?
Objection,
No.
Your Honor. This is asking answered and cumulative to the record at this point.
Objection is overruled. The answer will remain in the record.
Your Honor. Oh, wait.
Any redirect?
I'm sorry, Your Honor, I have one more question. May I go back?
You may.
Mr. Firehome, in your opening statement, you told the jury that Todd's prior statements to law enforcement were wrong. Do you remember that?
If that's what I said, yes.
And then you put your client on to testify in your defense without any corroboration.
Objection, Your Honor, from just clarification of the record purposes, I believe that's necessary to say your defense, I believe, should be clarified if possible to Mr. Mullis's defense.
Certainly, that's the way the court understood it.
Thank you, Your Honor.
Isn't that what I asked? I'm pretty sure that's what I asked.
Do you want me to repeat or rephrase the question?
Please.
If the transcripts show in your opening statement that you told the jury Todd was wrong when he talked to law enforcement, and then you put Todd on in the defense in chief and expected the jury to believe him, that was what you did?
What I told the jury is that Todd told law enforcement that she fell, that it was an accident. That's what he initially thought. He testified on cross-examination that it was a murder. So I'm not sure what you mean, I guess.
I'll move on and follow up on that, and I know I have to be done. Todd's testimony at trial is reflected in the transcripts, right?
Yes.
And so if the prosecutor asked him, based on what you've heard at this trial, do you now know it's murder? Would that be different than Todd's belief that it was murder versus an accident?
I can't say.
Okay, and Mr. Mullis wasn't qualified to review the autopsy report or do an accident reconstruction to have his own belief.
I'm sorry. What was your objection? I didn't hear it.
Well, one, this is irrelevant, and it's not facts in contest, so it's immaterial and far more prejudicial than probative because certainly no one is contesting that.
Well, I think we're getting a little far afield here. Sustained.
No further.
Okay, so Paul says Todd could have been in a rush when he set the rake in the red shed. We just don't know how the rake was positioned. It makes sense to put it tines down, but we just can't know. Also, I would agree with that, but also because there was such a length of time in between when Todd says he put the rake in the shed to begin with and when the when the incident, I'll just refer to it as incident because that's pretty much middle of the road. That takes no position. When the incident occurred, right, there was time in between the placement of the rake and the incident, a lot of time. And the red shed is something that everybody in the Mullis family had access to. So in theory, it could have been moved and then repositioned. So we absolutely have no way of knowing exactly how that rake was.
Further questions?
Any redirect?
Briefly, Your Honor, permission to share the screen?
You may.
Perfect. Drawing your attention to what has been marked previously as Exhibit
Wait a minute. Wouldn't it not be redirect? Wouldn't it be recross?
350, and specifically drawing your attention to page 75, line 25. Do you see that, Mr. Firehelm?
Yes.
So it says, I want to talk to you about some of the times that you're given. What's UTC mean on this printout? That was your question to Deputy Himmelsath, wasn't it?
Yes.
To which you responded Central Standard Time, right?
Yes.
And you just say, if the internet tells you you're wrong, would you disagree? And he said, can you ask that again? I guess I've never had the internet tell me I'm wrong, which I believe is a joke, or also just maybe in jest. In either way, have you ever researched that UTC is the successor to Greenwich Meridian Time, GMT? To which he responded, okay, I've never searched that, no, right?
Yes.
Now continuing down through page 77, line 5, let me know when you've reviewed it or if you need it slowed down. Have you reviewed it, Mr. Firehelm?
I see it.
And in this case, so you did actually impeach Deputy Himmelsath on UTC time specifically, right?
I thought I had.
And so the record would speak on that point. Would you agree?
Yes.
Did you author your affidavit that was referenced earlier?
Yes.
In the time, it was not authored with the benefit of having your file, right?
That's correct.
Nor when your deposition occurred did you have the benefit of your file. True?
That's correct.
Because you had given it to ensure that the successor attorneys representing Mr. Mullis could continue their representation in the underlying criminal case and on appeal, right?
That is correct.
Knowing now, with the benefit of the records and the transcripts before you, is your testimony today true and accurate to the best of your knowledge?
Yes.
I don't have anything further, Your Honor.
Anything further, Ms. Nichols-Cook?
Just, Mr. Firehelm, do you know if you've ever seen the cell phone extraction data from Tristan Mullis's phone?
I don't think so, no.
And then just for purposes of the record, do we need to identify if there's someone in the room with Mr. Firehelm or not?
We can. Mr. Firehelm, is there anyone in the room with you? I guess I'm not sure if you're in your office or elsewhere.
I got the door locked and I've been here by myself all afternoon.
Thank you. I guess back to you, Mr. Duden. There was another question from
None
your
needed,
side.
Your Honor.
You're done?
Yes.
Okay. All right, Mr. Firehelm, it sounds like that should conclude your testimony.
Okay, so Patricia says, I think I would rather have Bindi defend me than Alan Jackson if I was innocent. And while that is a huge compliment and I appreciate it tremendously, I'm not an attorney. So perhaps the better solution would be to have Bindi assisting the actual attorney in some capacity. Because I am definitely not an attorney. And so, yeah. So Charlie asked, is there any reason why they never thought that the son did it? He did find her. I think the reason, Charlie, that they never suspected Tristan is because Tristan didn't have a motive. And he didn't voluntarily go find his mother. He was told to go look for his mother. See, she was sent to that shed to retrieve a pet carrier to contain these kittens, these orphaned kittens, and to keep them out of danger. And both Tristan and Todd have never changed that story, that after a period of time, after Amy left the hog barn where they were all working together, and Todd had a moment and he looked out the window and didn't see her place the red shed or the carrier out of the red shed outside. He then sent Tristan to go check on what was the status of this carrier. And that is how Tristan found his mother. So I don't think I don't think he was ever a suspect for that reason. And Paul says, like, hey, daughter, did you look up parts of the body with your dad about your mom's surgery? Hey, daughter, are those questions from your hunter safety course? And then Paul says that you have to know the original trial to get that. And I feel like I can't remember where that came up in the trial. Paul, come on, help us out. All right. So I'm going to rewind so we can go back to the beginning of the day and hear the first witness. Hold on. Let me make sure. Let me just skip forward just briefly, really quick.
All right, great.
Before we do that, I want to show you guys this Google search that I did. Okay. So at the top here, let me make sure it's on the screen. Okay, perfect. So at the top here, it says, you can see that I Googled what burden of proof is required to mount a successful ineffective assistance of counsel appeal in Iowa. Okay. Because I want you to know that I Googled specifically to Iowa. So the AI overview is this: to successfully claim ineffective assistance of counsel on appeal in Iowa, a defendant must prove by a preponderance of the evidence that their counsel breached an essential duty and that this breach resulted in prejudice, meaning there is a reasonable probability that the outcome would have been different. Here's a more detailed breakdown. Burden of proof. The defendant, as the appellant, bears the burden of proving both deficient performance by counsel and prejudice resulting from that deficient performance. The appellant must demonstrate that their counsel's actions fell below an objective standard of reasonableness, meaning they made errors so significant that they were not the type of errors a reasonably competent attorney would make. Prejudice. The defendant must demonstrate a reasonable probability that, but for the counsel's unprofessional errors, the outcome of the proceeding would have been different. This means a chance that the outcome would be favorable to the defendant if their counsel had acted differently. Presumption of competence. Courts generally presume that a lawyer's conduct falls within the wide range of reasonable representation. The defendant must overcome this presumption by providing evidence that their counsel's actions were indeed deficient. Post-conviction relief. An ineffective assistance of counsel claim in a criminal case shall be determined by filing an application for post-relief pursuant to Chapter 82. This is why it's difficult, okay? Because fell below an objective standard of reasonableness, okay? Errors so significant that they were not the type of errors a reasonably competent attorney would make. I think probably, in my opinion, looking at this, right? The best chance at proving this claim is in not requesting for a mistrial after the 911 call was played during cross-examination of Todd Mullis during his testimony. When the state cross-examined Todd Mullis, they played a portion of this 911 call, okay, that they allege said, "Go to hell, cheating whore," and another utterance, okay? Under the rules of procedure, criminal procedure, when they got this quote unquote tip from somebody who'd watched it on court TV, something to that effect. Bottom line is they received a tip, okay, about this this utterance, these things that were muttered during this 911 call, okay? They did not follow proper criminal procedure. The state would have been required to disclose that to the defense prior to asking about it during cross-examination, and they didn't. And so I think that his best chance on an ineffective assistance of counsel is that, because a lot of the things that have been put forth so far, and this is so far, my opinion can change. We still have another witness to listen to today, and then we have all of day 6. Okay, not asking it is my opinion that that the suggestion that is what was uttered on that, I should say muttered, really, that Todd muttered those statements during that 911 call was highly, highly prejudicial. And the defense had no opportunity to have that independently analyzed and verified in any way, shape, or form. I think of all the things that the defense did or didn't do in this case, for me, that might be the one that is likely to be the most successful, because it seems to me, based on all the testimony we've heard thus far, that really what this boils down to is trial strategy. The original defense attorney felt the best trial strategy was to argue, or to show an alternate suspect. And that is, I think that is, that's subjective. What's going to be successful versus what's not going to be successful. And it's based on, prior experience, education, so I actually think that the best, I think the best chance he has at being successful with this ineffective assistance of counsel is respective to not doing something during the trial about this evidence that was admitted without disclosing it first to the defense counsel. I think that's his best chance, honestly. So, all right. So let's go to the first witness for day 5.
Morning, sir. Come forward, please, and have a seat in the chair to my left. If you'd raise your right hand. Do you swear the testimony you're about to give will be true and correct? I do. Okay. The microphone is on. Just adjust that as you need to so you can sit comfortably. Ms. Neshwat, whenever you're ready.
Good morning.
My name is Dina Neshwat. I'm one of the attorneys for Todd Mullis. Would you please state and spell your name for the court reporter?
Yeah, Blake Heeman, Blakehemann.
Mr. Heeman, where are you employed?
Farm Credit Services of America.
And what do you do there?
I'm currently a sales skill trainer. Previously was a crop insurance agent.
How long have you worked for Farm Credit Services?
16 years.
How long did you work as insuring crops for farmers?
Approximately 13 years.
So do you have a general understanding and knowledge of planting practices?
I do.
In your... Yes. Is that better? Is that better? You just said you had experience with the planting industry, farmers. Can you give me just a general idea of your interactions with them in your 13 years insuring crops for them?
Sure. The crop insurance process is pretty straightforward. I'd say the biggest requirement is understanding what coverage the producer wants, and then there's some key dates and times that need to be met throughout the year with that process to make sure that they're insured properly.
Do you recall what those key dates are?
There's several. So sales closing date is March 15th. There's some planting dates. So like corn, to get full coverage should be planted by May 31st. Beans, I believe, is June 15th. Then there's some other reporting for production in as well. So.
And those are required dates?
Correct.
Is there a window of time planters have to have all of their information submitted?
Yeah, so like acreage reporting, July 15th is the deadline to have that reported.
Who is that required by?
USDA, along with the AIPs, the crop insurance agencies.
Are you familiar with the Mullis family?
I am.
Are you familiar with their farming operations?
I am.
Who in the Mullis family are you familiar with?
All of them, the whole family. Todd, I'm familiar with Amy, Pat, all of the whole operation. Mike, Leroy.
And Leroy is the father of the 3 males that you just mentioned?
Correct.
And you said Amy also, Amy Mullis?
Yep.
And you insured crops and farmlands for those members of the family as well in their farming operations?
Correct.
Okay. Mr. Heeman, can you explain what an acreage farm book is and its purpose?
Yeah, do you have that example? Or
I'm going to do that in a moment, but just generally.
generally speaking, when the producer comes to us and says, I planted this crop on this day, we map that for them to get it in the system to essentially certify those dates, crops, locations for them.
And is it a farm book or a frame book? Forgive me.
I know they're referred to by some maybe as a frame book. We call it an acreage report.
Okay. Is this something that's generally you prepare for each of your farmers?
Correct.
Is that annually you prepare?
Correct. Annually.
Did you prepare an acreage farm book for Patrick Mullis?
I did.
I'm sorry, Patrick and Judy Mullis.
I did.
Do you know what information was included in that acreage book for Patrick and Judy Mullis in 2018, just generally?
Yeah, acres, type of crop planted, and the plant date, along with PAT certification that everything was correct.
I'm going to show you, Mr. Heeman, a redacted report. It's Exhibit 378. And, Your Honor, redacted is just the privacy, personal data, phone numbers, Social Security. The 2018 acreage framework. Do you see that in front of you?
I don't.
I'm going to give you my copy.
Okay.
For a moment. Can you pull up on the screen for me? Give you a moment to skim it.
Your Honor, the court previously received a copy of this on its hard drive if the court needs to see it.
I'm able to access it. Thank you.
Thank you, Your Honor.
I'm familiar with this book.
Because you created that book to put it
Correct.
together.
Yep.
What year does this acreage report cover?
This one says 2019. I'm sorry, 2018.
So just to confirm, the one in front of you covers is report.
2018.
2018, is that what you said?
Correct.
Do you know when it was prepared?
Should say on here. This was done on June 12th,
And you said the information is required to be submitted by June 15th?
July 15th.
Okay.
This copy was created on June 12th. I don't know, the copy that I had seen before had a signature on it. This one does not. So there's a chance that we did it before June 12th as well.
Okay. What page? Mr. Heeman, would you turn to page 22? Do you see a signature on that page? Well, a redacted signature.
So on the actual acreage report, this would be a signature area where we would need a signature. If you're referring to the other 578s, is that
Is that
the one
the
you're looking
one?
at? That's a different signature.
What page would that be on?
I don't see page numbers.
I can't give you a PDF number, so hang on one moment, please. We're going to show you
Sure.
with the court's permission.
Certainly.
Of the electronic document.
Yeah, so that document right there is the certification from the Farm Service Agency. And so that signature would have been the date that Pat certified those acres with the FSA office or Farm Service Agency, which is separate from our acreage report.
Okay. Mr. Heeman, so again, in this report, is there mapping information in there regarding fields that the farmer would own or be affiliated with in renting, for example?
I'm going to object. One, I don't know if we're admitting this exhibit. The state certainly objects to the admission of the exhibit, so right now it's assuming facts, not in evidence. I'm also going to object because it's irrelevant. It's not Mr. Mullis' farm specifically, so under those grounds, as well as 5403 prejudice, as it would be misleading.
Did you wish to respond?
Yes, Your Honor. I'm not asking for specific information. I'm asking generally, are there mapping, what is included in that report, just generally speaking, and there will be foundation in just a few more questions, and it's certainly relevant because it gives information to support that certain allegations by the state or testimony in the underlying trial by the state is false, and we'd like to show that with this, what the court is about to see.
Well, I mean, at this point, I guess I don't have any information to tell me what these maps or this information has to do with Todd Mullis. Maybe we could lay that foundation and then move forward with the specific information about this exhibit.
And a few more questions, I think I can establish that.
Sure. Why don't we
Yes.
go there and then we can come back to the exhibit?
Sure.
Okay.
The foundations. Mr. Newman, do you know who operated the planter for the Mullis family members' fields that you insured the crops for, from your understanding?
From conversations, I was aware.
Objection, hearsay and speculation, Your Honor.
Overruled.
You can answer.
Okay. From conversations with the Mullises, there was an understanding that Todd operated the planting equipment on occasion.
Did you have any reason to believe that that information wasn't true?
No.
You actually insured fields for Todd and Amy Mullis and their farming operation, is that right?
Correct.
Do you know if Farm Credit still insures Todd and Amy Mullis's, their property that was insured in 2018? Is it
far
still
as I'm
insured
aware,
today?
Yes.
Can you say that again?
As far as I'm aware, yes.
And also Pat and Judy Mullis's property, is that?
Yeah, I'm not in that role anymore, but as far as I'm aware, yes, we do.
In 2018, have you ever met Todd and Amy Mullis before in person?
Yes, on their farm.
Do you know what year that was?
2018, around that time frame, probably more than one occasion.
Okay. Can you just, what was the situation, where did you meet them? What were they doing?
In some cases, it would have been signing acreage reporting documents or other crop insurance documents or deciding what coverage to take. In other instances, just on the farm, stopping in to say hi, see how things were going.
So you saw Amy and Todd Mullis together?
On one occasion, both of them together, yeah, that I can think of.
Okay. Do you know if there's anything unusual about them together, demeanors?
No.
Odd? Have you ever seen Todd working on a planter or fixing a planter in front of his shop anywhere or on the farm?
On that occasion that I was just speaking of, I mean, when we stopped in, I remember the planter equipment being there. It was about this time of the year. Seems like Todd was working on the equipment, again, in his yard in front of his shop.
Okay. Okay, Your Honor, I'm going to go back to the showing Mr. Heeman a copy of the redacted report, if that's okay.
You can, I guess let's see what the questions are.
Mention report.
It's over. You have it, yes.
You have it in front of you?
The paper copy?
Mr. Heeman, this book, again, you prepare for your farmers annually, is that right?
Correct.
About how many farmers or is it farmers or producers that you call them? Either?
Yeah.
How many of those did you have at the time you were working in this capacity as a?
Objection to relevance.
Overruled. You can answer.
90, I would guess, somewhere in that ballpark.
So did you create one of these books in the ordinary course of business for your farmers?
Yes.
Your Honor, we'd offer Exhibit 373, the frame book, for Mr. Heeman, just to clarify, was this book created in the ordinary course of business as your standard practices for your farmers?
Yes.
Your Honor, the applicant would now offer Exhibit 378, sorry, into evidence.
Any objection?
Yes, Your Honor. For the same grounds, it would be misleading. It's more prejudicial than probative under 5403. This is Pat Mullis's farming record, so it's irrelevant to this proceeding, and doesn't speak to Todd Mullis's planting habits or even whether or not he was the one planting, even based on the foundational testimony of the witness here. So it is more prejudicial than probative and irrelevant to this proceeding and immaterial.
Again, I guess all I've heard to connect it to Todd Mullis is that on occasion he operated the planter that I guess potentially planted the crops that would be referenced in this report. So I agree, it's way too tenuous at this point. It's not going to be admitted at this point. If you want to continue to lay some foundation, you certainly can.
Mr. Heeman, between the Mullis family members, there was Mike, Leroy, Pat, Todd, and Amy Mullis. You insured their fields?
Correct.
From your knowledge of all of those fields that are insured, crops are insured, was it that Todd Mullis was the one that operated the planter for those fields?
The primary operator of that equipment, again, through conversations, was
Objection,
always that.
hearsay and speculative, and it's leading, Your Honor.
Overruled.
You can answer.
In those conversations, it was often talked about that Todd was the operator of the planter equipment.
Do you have any reason to believe that he was not the operator of the planter?
Objection, Your Honor. Again, we're just speaking to another farm book. It's completely irrelevant to this proceeding and speculative at this point. If you'd like me to voir dire the witness and ask if he has specific knowledge about specific instances, I'm happy to do that. But it is speculative here because it's trying to say it's action in conformity with another document that hasn't been admitted.
You may voir dire the witness if you'd like.
Thank you. Good morning, Mr. Heeman.
Good morning.
You mentioned previously that you insured all of the Mullis family farms. Is that fair?
Correct.
On any specific date and time, were you present when Todd Mullis was planting?
Not to my knowledge.
Can you name any specific date or time as it relates to when he would have engaged in planting on any one of the Mullis farms? Specific time frames?
That I witnessed?
Yes.
No.
So is the full value of your ability to speak to whether or not he planted in his fields or in another Mullis family field based on what you've heard and what has simply been relayed to you?
That would be correct.
Your Honor, the state would object on the same grounds.
Again, 378 is not going to be admitted at this time.
One moment, Your Honor. Could you give me one moment, please?
Certainly.
You said you're familiar generally with farming, planting industry. Have you ever ridden in a tractor before that's pulling a planter?
Objection, relevance.
Overruled.
Yes.
Generally speaking, do you know how fast a planter moves in the field or tractor moves in the field?
Depending on the equipment, it's probably average 5 miles an hour, I would assume would be a good estimate.
Okay. Does the size of the planter impact planting time?
Sure.
How about the shape of the field? Does that affect planting time?
Yes, I mean, a square field that's flat is going to plant easier and faster than one that's got waterways or point rows in it.
Do you know if do you know the size of the planter that Todd Mullis used when he planted his own fields?
No.
You don't know if it was a 16 rows, 24 rows?
I'm not familiar with what size it was.
Okay. I don't mean to put you on the spot, but do you by any chance, because you're, do you know if do you know the size of the planter that Todd Mullis used when he planted his own fields?
No.
You don't know if it was a 16 rows, 24 rows?
I'm not familiar with what size it was.
Okay. I don't mean to put you on the spot, but do you by any chance, because you're insuring the fields, know how many feet are in an acre?
Oh, I should know that.
Oh, you do?
I should know that. I'm sure I knew it at one point. So the answer would be no. Not today.
It's the information generally that is provided in the books that you created. Is that reported to the FSA? Is that what it was?
This information in our books, that when we do our crop insurance reporting, our acreage reporting, we're submitting that information to the approved insurance provider, who is essentially the underlying reinsurer, so the company that's holding the insurance.
Without looking at the book in front of you, do you know the areas of the fields that you insured for several years for Pat and Judy Mullis?
Objection relevance.
Overruled.
I'm familiar with them, yes.
Do you know the radius between, I'm sorry, ask a different question. How many fields, if you know without looking at the book, did you insure for Pat and Judy Mullis?
Yeah, ballpark 7, I'm going to guess.
Do you know the radius between those fields?
I would say all within 20 miles of one another.
Okay. When someone is planting, do they need to refill whichever crop they're planting with certain items? For example, fertilizer or?
Yes, the seed, fertilizer, some chemical.
How often does a planter break down, so to speak?
According to the producers I talk to, too much. So they have the wear and tear affects them. They do break down, I would say, often.
I just want to clarify one last point. You said it was 2018 that you had met Todd and Amy Mullis,
As far as I can recall, yes.
and at one point you saw them together,
Yes.
and you didn't notice anything odd or about their demeanor or relationship.
No.
Okay. I have nothing further, Your Honor.
Cross-examination, Mr. Duden?
Briefly, Your Honor. Good morning again, Mr. Heeman. You managed the insurance policies or services for the Mullis family for a number of years, is that fair?
Correct.
And your agency has done this since at least 2018, right?
Correct.
Up to the present?
As far as I know, correct.
And based upon your testimony, you first met Todd and Amy Mullis personally in 2018?
Objection, Your Honor, that's not what you said.
Overruled.
Is that correct?
First met them, I believe that's when I took those policies back over. Correct.
And so any paperwork that would have gone through your agency would have been signed by them on their property?
Can you clarify with any paperwork?
When you had them sign or certify the farm paperwork at issue, or that is relevant to your agency, would that typically be done on their property?
Not always.
Did you meet Todd and Amy Mullis on their land specifically, though?
It's on occasion, yes.
And on the number of occasions that you interacted with them, it would have been on their land?
Generally, I would say probably more often than in the office, if that's what you're asking.
And today, you can't say whether or not Todd Mullis engaged in any planting for a family member, can you? On a specific date in time?
Not that I witnessed, personally.
Were you asked to sign an affidavit in this case?
Yes.
Did you sign an affidavit in this case?
I did not.
Why not?
Because the affidavit asked the same question you just asked me, to essentially say that I saw or knew of Todd planting every acre on a specific date.
And you couldn't do that, could you?
I can't.
To the present, does your agency still manage the farm insurance policies for the Todd and Amy Mullis land?
As far as I know, yes.
And as far as you know, that land still is placed within the Todd and Amy Mullis Living Revocable Trust or within their names, correct?
Objection, Your Honor. How would you have that information?
Overruled. The witness can answer if he knows.
I don't know the answer to that.
Okay, so Charlie says, I'm not understanding why who planted when is important. I believe that this portion, I think there's overlap in the both of the claims and the evidence that the applicant defense wants to use in support of those claims. Remember, there's the actual innocence claim, and then there's an ineffective assistance of counsel claim. But there is overlap. I think in this situation, I think the reason that this specific witness has been called to testify is he is intended to be able to refute the Google searches by saying that it's based on his experience with Todd Mullis, Todd and Amy Mullis's farm, and his experience in general doing the insurance, that this is the time of when Todd would have been in the fields planting crops, and therefore unable to perform those Google searches. So, look, Paul answered. Yay, I got it right. Charlie, because the farm logs show Todd was in the field planting at the time of some of the more incriminating searches were made. So there we go. That's what it was. I got it right. Yay me.
What it's insured under or who.
So from what I've gathered from your testimony, you knew or believed that Todd Mullis would on occasion assist with planting in his family's fields. Is that correct?
Objection, Your Honor. He didn't say on occasion.
Well, the first time he did use the word on occasion, so the objection's going to be overruled. The witness can answer.
And I can clarify that. So I should clarify, as far as I knew and was told, Todd did the planting of all crops for the Mullises in the past and up to that point.
But that was all based on what you heard from other people, wasn't it?
My conversations with the Mullises.
So it was self-reported.
Correct.
And to date, you've never witnessed that, right?
I cannot recall a time when I witnessed Todd in the planter tractor on a specific field, no.
And even the information that's included as to what date it's planting occurred in any specific year or time frame is self-reported. Is that fair?
It is.
So you aren't cross-verifying that information, right?
Correct, no.
Nor are you certifying that information yourself, right?
We take producer's word for it. They're certifying that that's accurate. Yeah.
I don't have anything else, Your Honor.
Can you redirect?
Yes, Your Honor, just a couple, please. Mr. Heyman, if you were to look at Pat Mullis's acreage book, would you be able to determine the fields that were planted in 2018?
Yes.
Objection, Your Honor. Again, we're referring to facts potentially not in evidence, and that has already been deemed or excluded by the court.
Objection's overruled. The answer will remain in the record.
The information about Todd Mullis planting for the rest of his siblings and the Mullis family's members' planting operations, did you have any reason to believe that that information was untrue?
No.
The farmers or producers, you said you take their word for it.
Objection, leading.
He just said that.
Well, is there a
I'll
question?
withdraw, Your Honor. The information that they're providing to you is to get insurance on their crops. Is that correct?
Correct.
Would you say that planting and crops and the yields returned are their livelihood?
It's specific to crop insurance. It's the way they manage risk to ensure they can continue to run their operation.
So they would have every reason to report it accurately.
Objection.
Do you agree?
That's a credibility call and leading, Your Honor.
It is leading. Sustained.
Paul says, you might remember they made a point of talking about whether the iPad had built-in cell or if it was just Wi-Fi. Then they asked how far into the field one could operate the iPad using Wi-Fi. And Paul says that he thinks that the testimony came in with Hemaseth and then again with the IT expert. And also, to your point, these searches were made well in advance of the incident. And so I think it is far-fetched for the state to try to imply that this was somehow coordinated in an effort to give Todd an alibi, as it were. That's just... Oh, hold on a second. Well, welcome in, Carolyn Cooper. Carolyn Cooper says, I'm listening and cleaning. Thank you for being here and listening. Farm Credit caught my ear. I worked there for 36 years. Wow. Small world. All right, here we go. Do you have some type of objection you'd like to raise, Mac? Here we go.
Mr. Heeman. I have no further questions, Your Honor.
Any requests?
No, Your Honor.
Thank you, Mr. Heeman. You may step down.
Leave this here.
Sure. Further evidence on behalf of the applicant.
Your Honor, I think it might make sense for the parties to confer with the court briefly about scheduling from here.
Okay, let's go ahead. We'll go off the record, take a short break.
All right, so they do go off the record. They do take a short break. Hold on, let me see what else is happening here.
Of Mr. Firehelm's testimony, and he will actually be appearing by Zoom. Is that the plan?
Yes, Your Honor.
All right. We'll plan on that then. Counsel, I know we have a few things that we can take care of, and you will be working on some other details as well off the record, but we'll plan on resuming in the courtroom on the record at 1 p.m. Anything else then that we need to address?
Okay, so this would be the end of the testimony for day 5. Charlie asked if we could listen to the 911 call, and that came, hold on a minute. Hold on a second. That came during Todd's cross-examination in his retrial. And since we have time, because today was a short day for testimony, I'm going to play that part of the testimony in its entirety. Let me just get to the right part. Are we ready? Earbuds in. Here we go.
Ms. Hughes, go ahead.
This space battle made video game history. Thousands of players flying player-built ships, each with their own story.
Now, Todd, I just want to
Hold on, let me change that so that I can be on the right account so that we don't get ads. Would have been nice if it could have kept it completely like I had it, right to the precise moment. All right, now let me share. Also, to answer your question, Charlie, probably not. YouTube decides how they're going to do it. So I'm sorry for that. I don't have any control over that, babe. All right. I mean, I do typically monetize the stream prior to going live. And I do that because, to be quite frank, I think everybody knows this about me, but maybe somebody is new listening now. We're going to listen on the replay. I am very, very easily distracted and I forget. And so if I don't do it, if I don't make it a habit to turn it on at the time that I schedule the live, then I forget to do it, period. So that's why. All right, here we go.
Now, Todd, I just want to talk a little bit more about a few more things. So when you call 911 on November 10th, 2018, and you pull over because 911 tells you to, right?
Yes.
And you pull over and they tell you to get Amy out of the car.
No.
Or, I'm sorry, to lay her flat.
Yeah,
Because they want you to be able to do CPR. You remember that? Because eventually you do some CPR on her. Is that right? And just so that we all understand, where is it that you perform the CPR on Amy?
I started in the truck.
In the truck. And are you in the truck until Luke Thompson arrives?
I'm standing.
or I'm sorry, you're like leaning inside the truck, would that be fair to say?
Yes.
And is she seated in the passenger seat with the seat down?
Yes.
Or okay, so when they tell you to do chest compressions, half of your body's in the car, and that's what you're doing. You're using your mouth and your hands to do that.
I did not use my mouth.
Oh, I'm sorry. So you're just pressing. Where's Tristan at that point?
I told him to go stand by the road to flag them down if they were coming.
So as you're doing those chest compressions, is anyone else there initially?
No.
And you're holding onto that phone and you're doing the chest compressions.
I had my shoulder holding my phone against my ear.
So at that point, the only people in the car are you and Amy, right?
Yes.
And at this point, you don't at all think that Amy's cheating on you.
No.
You confronted her, you put it to bed.
Yes.
You, even after the rumors a month later, you still didn't think she was cheating on you because she told you she wasn't. Right?
Yes.
And even in those months, I know you told some people she was really moody. She was having some issues, right?
She had a lot going on all summer.
So because she had all the stuff going on in Ankeny, right?
Yes.
She was going up there. She was visiting a lot.
She had her grandma die. Her uncle had problems.
You said in those 2 months, in September and October, she was gone about 30 days.
There was a stretch in there. Yeah.
And she would come and go, but she was gone quite a bit, right?
Yes.
And things are getting a little bit tense at home.
No.
So you're not upset at all about this?
I was needing help at home, and
Right. And
I guess you could call it some tension, I guess.
well, and you're calling Eileen Fuller, Amy's stepmother, around this time, right?
Yes.
And you're telling her, this is hard, right? I'm harvesting,
Yeah.
I'm
Yeah.
taking care of the kids, and I know
Yeah.
Amy's got stuff going on, but I need some help, right?
Yes.
And thankfully, you have your family close by, and they're helping a lot.
Yes.
But still, throughout those months where she's spending a lot of time in Ankeny, you're not worried that she's cheating, right?
No.
You know she's just dealing with her family, right?
Yes.
And would it be fair to say you almost like forgot about the whole thing with Jerry Frazier because you didn't think anything was happening?
I did not put Jerry in
And
at all.
And so on November 10th, 2018, when this happens to Amy, you're not at all suspicious that she's cheating.
That she's cheating? No.
At that point, you don't have one worry that she's cheating.
No.
And when you're actually there giving her CPR and you're giving those chest compressions, all you're thinking about is your wife, right?
Yes.
You're thinking about how you're trying to save her life.
Yes.
And you're thinking you're doing everything, because I think you even say on the 911 tape, I'll do anything, right?
When they asked me to do CPR, I said I'll do whatever will help her.
And you mean that. You'll do anything at that point to help save your wife.
Yes.
And you start those chest compressions, right?
Yes.
And you heard that tape when we played it the other day, right?
Yes.
And at that point, what are you thinking when you're doing that?
Trying to get her to come back.
You're just trying to save her,
Yes.
right? Todd, while you're doing those, I know it was kind of hard to hear on that tape, but you're doing those chest compressions. How long do you think you're doing them for?
Not very long. Minute or two.
And then I think it's Deputy Thompson shows up, and then
Yes.
Does he take over or somebody else takes over?
He started.
Okay. Your Honor, at this time, can I publish a clip of the 911 tape?
Yes, go ahead.
And just for the record, Judge, this is State's Exhibit number 2. Now, Todd, here I'm gonna play you the part where you're doing the chest compressions, and I'm just gonna ask that you listen in between the chest compressions, okay? hear that whisper at the end of that?
Yes,
And what did you whisper?
I couldn't hear it.
Okay, I'm going to play it again. Todd, do you whisper cheating whore right there?
No,
So you don't remember what you whispered?
no.
Okay, I'm going to play another clip for you.
All right. There should have been 2 objections right there, in my opinion, just based on watching other trials. Okay. This was an ambush on the part of the prosecution. The reason that they're even playing this 911 call at this time is because after it was played in the original trial during the state's case in chief, there was a tip that it sounded like Todd said cheating whore and then go to hell cheating whore during the 911 call. So the prosecution listens to it. They determine, oh gosh, that's what he said, right? So then when Todd gets on the stand, they play this. These, according to the rules of the argument is, according to the rules of criminal procedure, statements like this coming from the defendant should have been told to the defense, that the state had a duty, an obligation. Hold on a second. The state had a duty and an obligation prior to when they decided to do this to let the defense know. Okay, so there should have been an objection there. And there should have been an objection. Hold on, let me play it again.
Whisper cheating whore right there?
No,
So you don't remember what you whispered?
Right there. She asked the question, did you whisper cheating whore? And then she says, so you don't remember what you whispered. There should have been an objection because it mischaracterizes the testimony. He answered the question. He said he didn't say it. That's where I was going. That's where I was going. Why didn't the defense attorney object to her insertion of the narrative? That's problematic. All right, here we go. Let's keep listening.
no.
Okay, I'm going to play another clip for you. Do you know what you whispered there?
No.
Did you hear that? So I'm going to play that part one more time. The first clip is 6:53 of that second tape. And this second one is right at 0700. Just try to listen really closely. I just want to know if you remember what you said.
And there, I just want to know if you remember what you said. Well, that's a narrative. All right, I will, Paul. I think I understand. I think I know what that video is about. And the thing, okay, so basically, well, I'll check it out and then we'll talk about it after I watch it. And I need to like watch it, digest it, probably watch it again, just so that I can accurately understand what's being conveyed and then respond. It takes me a minute. But he never said that he said anything. And there's no objection to this in any way, shape, or form. And that is a problem. This is where I think Todd Mullis has the best chance. It's this evidence that I think gives Todd Mullis the best chance at being successful in an actual or in an ineffective assistance of counsel claim. Because I think this is a very, very clear indication or example of ineffective assistance of counsel. There should have been a mistrial declared right here, right now. I think that when you tell somebody what to listen for, they are going to hear what you tell them to listen for. There's studies on it.
Right there, do you say, go to hell, cheating whore?
No,
So you don't hear that?
no,
You didn't hear at 6:53, cheating whore? You didn't hear that?
I didn't hear that word.
And it's right at that, after you hear a ping, you don't hear, go to hell, cheating whore?
No.
So why all of this would be problematic is because if you'll notice, when she's questioning Todd about it, she repeats the phrase, I should say, phrases that she says that are uttered, muttered, said on this 911 call, on this tape. Now, there's also another little bit of a social experiment that was done where if you notice when somebody is really working hard to sell you something that they will repeat a phrase 3 times, that there's been studies that have been done that report that there's something, I guess 3 is the magic number, that that a person is more likely to remember and also believe what someone says when they repeat it 3 times. There have been studies done on this as well. And now that she has repeated those alleged phrases 3 times, it's quite likely, it's like you can't unring a bell. You know, it's the reason that that all of the king's horses and all of the king's men couldn't put Humpty together again. You just, you can't put the toothpaste back in the tube either. Once heard, it can't be unheard. And then, I mean, there's an actual name for it, and I'll go watch that video that Paul's suggesting to me. But this is why this is particularly problematic, and why he should have objected immediately. They were ambushed.
I have nothing for you, Judge.
Any redirect?
Thank you.
Todd, the state asked you if Amy wanted to quit the hospital after this first affair. Remember that question?
Yes.
Do you remember her announcing to her friends and coworkers that she was leaving the hospital?
Yes.
How did she do that?
She did a Facebook announcement, and she even had a party at a bar.
Okay. When you and Tristan realized that the pet carrier wasn't up by the shop door, what did the two of you try to figure out, or what did you decide to do, I guess is a better question.
We were just talking. I wonder why it wasn't there. What she either couldn't, we were thinking that she either couldn't get it out of there, or she didn't even attempt.
She didn't even go over there in the first place.
One or the other.
Okay. And I'm just going to follow some questions along, so they may jump around. There's a series of questions about where Amy was located when you first saw her in the shed. And they also ask you about your knowledge of the advisability of not pulling something out of a person that's penetrated them. You remember those questions?
Yes.
Were you able to get Amy out the door with the fork stuck in her back?
There's no way.
So you didn't have a choice?
No.
You were also asked about when you last saw that fork, and you said something about the grass, on the grass, and that you moved it.
Yes.
In that shed, have you looked at all the photographs that the state took in there?
Yes, I think so.
Were there any children's toys in there?
Yes.
Well, what were there?
There was a multitude of stuffed animals and play items on the wagon.
The kids obviously played out there then,
Yes, they played a lot.
and things might get moved out of the shed that shouldn't be.
Yes.
You told the state that while in the hog barn that morning, you never went to the office. Is that correct?
After she left, I never went to the office.
Did you go through the office when you left, though?
Yes.
Were you in the office when you and Tristan looked out and didn't see the pet carrier?
Yes.
There also was some questions about the closest point between the hog barn and the red shed. And you tell us again what that would be.
I estimated at 150 feet or so.
And that'd be from what point on the hog barn?
The very, very southwest tip of the barn by the door that you go in and out to the very northeast corner of the red shed.
And when you say the door, that's the door going into the office of the hog barn?
Yes.
Todd, why did you do the searches on or about, I think it was July 26th, for Jerry Frazier and his wife?
I was trying to find a way to contact Christy.
Christy being his wife.
Christy was his wife. I was trying to find a way to contact her.
So if the search related to Jerry, you had Jerry's contacts.
I had Jerry's contact, but I had no way of getting her phone number.
On some of those entries, those searches that the state asked you, a few of them about thrill of the kill, thrill of the hunt, hunt man, thirst for hunt, that kind of thing. You indicated you recognized those.
Yes.
And what did they relate to?
There was a quote stated in a movie, and it was actually ended up being an Ernest Hemingway quote, and we were trying to remember what it was.
Do you remember what the name of the movie was?
I think it was Predators.
Kintu Sukuroi. And Violet says, or like Sarah Boone, quote, in Japanese culture, when something is broken, it's put together with gold and enhances the flaws. Yes. Kintu Sukuroi. I think it's actually Kint Sukuroi. But, you know, Sarah's the smartest person in the room all the time. I had another point that I was going to make. Oh, I know the point that I was going to make. We don't have that much of his testimony left. I'll save it until until this is over. Okay, so recliner detective asks, is the prosecutors paid by the state or from Todd's money? The prosecutors are always paid by the state. Todd, the only thing that Todd, if he were paying for anything, right, would have to pay for is the appellate attorneys. You, as a United States citizen, if you are convicted after a trial, whether that is a bench trial, a criminal trial where the fact finder is a judge, okay, or a jury trial, we all are familiar with that, you have the right to appeal your conviction. You're not charged, and for the state to defend the conviction, the defendant doesn't get charged for that.
Todd, did you ever have any doubt about you being the biological parents of your children?
No.
Do you have any reason to search for those DNA things?
No, I have no reason to.
Well, Tosh, if it makes you feel any better, I didn't think that you were Sarah Boone-esque in any way, shape, or form. I like to learn about those things. It's interesting to me. Wait a minute. Hold on a second. Hold on. Kauai Tosh, is one word. Am I understanding that correctly? And all of it means that you're little and cute? That Tosh isn't like a nickname short for a longer name that starts with N? Is that what you're telling me? Did I misinterpret this whole time incorrectly? I still, even if I did, or if I did, I still would like the record to reflect that I do not in any way, shape, or form feel that your correction or explanation is Sarah Boone-esque.
State asked you questions about you contacting Jerry and his wife in July of 2018. They said, I think the words they used was, did you confront them about the affair? Had you concluded that there was an affair?
No, I did not.
You had concerns about all those text messages?
Yes.
When you talked to Jerry, did he convince you that there was nothing going on?
Yes. I mean, for the most part, yes. He was very convincing.
Todd, when you were doing those chest compressions, if I understand you correctly, you had put Amy somewhat upright in the seat of the pickup, but leaned it back as far as it would go?
Yes.
So she was in a kind of a reclining chair position?
Yes.
And you were holding the phone and doing the compressions at the same time?
Yes.
You knew you were on a recorded line with a 911 operator.
Yes.
Do you believe that you whispered, cheating whore or go to hell, cheating whore, while you were doing CPR?
No.
And now it's been repeated, for the fourth time? So it's really stuck in the jurors' minds. In fact, I am very curious, and we still have a whole day tomorrow. I'm very curious if the appellate attorneys spoke to the jurors that rendered their verdict in the original trial. Because what I'm really curious about is if they did speak to those jurors, if they asked those jurors how much weight, if any, that 911 call played during the portions played during Todd's cross-examination, what weight, if any, they gave it during their deliberations. Because I would suspect they did, I would suspect they did give it some weight.
Were you frantic?
I was very excited.
Another bad choice of words.
Were you doing?
That saying, okay, when you are performing life-saving measures on a loved one, frantic was the correct word, right? Excited implies something else to most people. It just hits your ears wrong, right? I wish that he'd have been prepared I wish he would have been instructed by his attorney not to use that term excited when describing how he felt giving Amy chest compressions, because it implies like you're, moments away from, breaking out into song, singing Ding Dong, the Witch is Dead or some shit. You know what I'm saying? It's not a good look. It hits your ears wrong. And it was a terrible question and denotes potentially a lack of prep.
Doing everything you could to keep her alive?
Yes.
No other questions?
You're just wondering if Jerry and Amy, if there's something, they're talking too much.
They were talking too much, yes.
So you didn't really think they were having an affair?
No.
But you did text Terry Stainer. Do you think Amy's acting like she was before? Right?
If that's what I text, yeah.
And well, you saw those texts, right?
I don't.
Do you remember seeing them the other day?
I couldn't see the screen.
Okay, but when you sent that text, you were referring to, is she acting like before, like having an affair, right?
Yeah.
And
He should have been prepped for this as well. And this is the reason it is so problematic for a defendant to take the stand in their own defense. This prosecutor, I have to give it to her, she's asking the questions in such a way that the impression I get is that Todd is agreeing that is possible, but not saying for certain that is what was going through his mind. But it's coming across when you're hearing it as at the very least, he was suspicious that they were having an affair. At the very, very least. And that goes to motive. And it's a problem.
you called Jerry Frazier's wife. I know you called a second time to apologize, but you called that first time to see if she suspected anything.
Are you ready?
All right, so there you have it. I think I'm going to let you guys go for today. I need to, there's a video that I wanted to show you guys, but I need to listen to it again. There's been a lot of testimony in between the time that I first listened to this video or watched this video and then right now. And I just want to make sure that I understand what's being talked about in this video before I play it for you guys. But so I'm going to let you guys go for today. For those of you who just joined or joined late, or for you guys on the replay, I just want to remind everybody that due to Paul's excellent email that he sent me containing very, very helpful notes, I have been inspired to do a video that recaps and highlights some important things that have occurred in this trial. And I'm only holding off doing that until we get to the end. We have one more day of testimony. Let me just make sure of that really, really quickly. Hold on a second. Let's just check. I'm almost positive there's 6 days, but let me make sure. Ouch. All right. I see day 6. I don't know why I Googled search day 6 when I know there's a day 6. I need to know if there's a day 7. Hold on. Let me see something here. Yeah, that's not helpful. Yeah. Yep. There's only 6 days. Okay. So we have all day tomorrow. Tomorrow's the last day of testimony here. Let's see what we have to look forward to. Let's see. All right. Hold on just a sec, you guys. That's his sister. Hang on, you guys. Just be patient. All right, so it looks like we have some interesting testimony tomorrow. But this is where I thank you, Paul. I appreciate that. Listen, Paul and Clicker are super, super helpful. They remember details that I have forgotten about, don't remember, or you just even don't know. So I appreciate the help. Really, I do, because I want to cover this as accurately as possible. That's important to me. I mean, at the end of the day, a woman, a mother, a sister, a daughter, an aunt, a grandchild is gone. And I believe that me reporting on this hearing, right, or covering this hearing, if by me being as accurate as possible, if it hurt as a victim, potentially, I mean, her story deserves to be told, and it deserves to be told accurately. If we're all going to be sitting around talking about her death, we might as well talk about it correctly. So I just am super appreciative that you guys are helping me so much. So thank you guys very much. Well, Charlie, the reason why she's saying that is because Charlie says, I hate the way she says right. If you break down her question, okay, up until the moment she says right, it's actually not a question. It's a statement. It is the right at the end of it that makes it a question. And that's why she does it, which I find you know, it's not she's not asking a yes or a no question. What she's asking is, right? Like, do you agree with me? I don't like it, but that's why I would say it's just not a good idea. The majority of the time, it never really works out in the defendant's favor when they testify. Of course, there's exceptions, but by and large, yeah, it doesn't. All right, you guys. So have a great rest of your afternoon, and I will see you back here tomorrow morning to go over Todd Mullis's day 6. Here, the day 6 of his hearing, and then I want to talk to you guys about what's next. All right, I will talk to y'all later. Have a good day. Bye.